It's a sizzling Saturday evening here in the drama-free true crime destination. Welcome one, welcome all to Bethea'S Byte Reloaded, and welcome to Saturday night's main event. Good to have you in the house. I'm Ernest Bethea, the last outlaw, and like I put in the community section, I've got loads of updates. I've got a couple new cases, a verdict watch, and I've got Julie Grant all coming at you right about now. But first, we're gonna get into our missing persons update. Pay attention to the left side of your screen. This is Amber Elizabeth Cates out of Columbia, Tennessee. Ashley has been missing since April 11th, 2004 out of Columbia. She was born February 3rd of 1988. She has light brown hair. She may have dyed it blonde, and she has green eyes. At the time of her disappearance, she stood about 5 feet 5 inches tall, weighs around 100 pounds. No word as to what she was wearing when she was last seen, or whether she has scars, marks, or tattoos. Amber Elizabeth Cates was last seen April 11, 2004 in the Columbia, Tennessee area. She was on her way to spend her spring break week with a relative, but has not been seen or heard from since the time she disappears. The FBI is offering a reward of up to $25,000 for relevant information leading to the recovery of Amber Cates or the prosecution of the person or persons responsible for crimes committed against Amber Cates. If you have any information regarding the whereabouts of Amber Elizabeth Cates, please do not hesitate. Call 911 or contact the FBI's toll-free tip line at 1-800-CALL-FBI. You're also asked to get in contact with your local law enforcement or the FBI's field office in Memphis, Tennessee. Or you can also submit your tip anonymously at tips.fbi.gov. Your diligence and information could be the difference maker in bringing Amber Elizabeth Cates home safe and sound. You're asked to please share this information with someone who may have valuable information that could bring Amber home. And always remember, if you see something, please say something. That way we can do something. Let's do all we can. Let's find Amber Cates and let's bring her home safe. All right. Now that we got that, now let's get right in and let's get down to business. First update we've got has to do with the alleged Gilgo Beach serial killer Rex Heuermann. I say alleged because one, he hasn't been brought to trial yet, and two, we don't know if this actually ties to him or not, but it's a possibility. So what I'm gonna do is take myself off the screen first.
I'm Vinny Politan. Thank you for joining us tonight on Closing Arguments, and we begin this hour with big news in the Long Island serial case. The serial killer. You've seen him before. There he is, huge guy. He's been charged so far with the murder of 4 victims. There they are. The Gilgo 4. But now we're understanding that he's going back to court to be charged with potentially a fifth victim or even more. Take a look from this reporting from the New York Post. The suspected Gilgo Beach serial killer will be slapped this week with murder charges related to additional victims, sources told the Post Monday. The accused killer, 60 years old, will be arraigned on a new indictment Thursday before the state Supreme Court Justice Timothy Mazzei. So let's go back in time. How did this all start? It started with Shannon Gilbert. She went missing in May of 2010, and this led to a search in the area where she was reported missing, and there was a discovery of several bodies. December 11th, 2010, while searching for Shannon, they discovered the remains of Melissa Barthelemy. She was found naked, wrapped in burlap. She's just 24 years old, was last seen alive in her basement apartment July 12th, 2009. She was the first of the Gilgo Four. 2 days later, December 13th, the rest of the Gilgo Four are discovered, all of which were also found nude, wrapped in burlap. Maureen Bernard Barnes, 25 years old, who went missing July 6, 2007. Amber Costello, 27 years old, last seen leaving her apartment September 2nd, 2010. Megan Waterman, 22-year-old mother of one, last seen June 6, 2010. Now, we flash forward to March 29, 2011. While searching an area along Ocean Parkway, police discovered the skull, hands, and right forearm of Jessica Taylor, 20 years old. But her torso had been discovered already in a wooded area in Manorville back on July 26th of 2003, 40 miles away, and years before. April 4th, 2011, just a few days after police discovered the partial remains of 3 more victims, a toddler identified as a little girl estimated to be about 2 years old. John Doe, an Asian man estimated to be between 17, 23 years old, remains the only victim yet to be identified, but was found wearing women's clothing. Valerie Mack, 24 years old, last seen in New Jersey in 2000. Authorities found her skull, hands, and right foot. And like Jessica Taylor, her torso was also discovered in the Manorville woods back in September of 2000. So you had Jessica Taylor and Valerie Mack, both who had partial remains that were found in this search. Now, April 11th, 2011, 1 week later, 2 additional sets of human remains were found in Nassau County. Peaches, given the nickname because of Peaches' tattoo she had, an African-American woman whose partial remains were first discovered in Hempstead Lake State Park. Through her DNA, she was identified to be the mother of the toddler who was found. And then Karen Vergata, 34 years old, when she disappeared on Valentine's Day, 1996. Her partial remains were discovered on New York's Fire Island in 1996, about 15 miles away. Long known as Jane Doe number 7, she was finally identified August of last year. Now later that year, December 13th, 2011, finally police discovered the original victim. The reason all of this was uncovered, Shannon Gilbert. She had gone to meet a client at his home on May 1st of 2010, had spoken with 2 neighbors before she disappeared. Now let's get back to that reporting from the New York Post. The indictment is related to additional victims, including one found in North Sea, a community in Southampton, which was recently searched by investigators. Let's take a look at the map. You've got Gilgo Beach, and then Gilgo Beach to the North Sea, and up in the North Sea, you can see where it is, all the way on the other end. Not easy to get to, right? You're not going to walk there by any means. And then Sandra Castilla, she was found there. So who is she? She's 28 years old. She was discovered beaten and strangled on November 20th of 1993, has long been thought to be the victim of a different killer, okay? So they're investigating this part, right? Searches in this part, but we go back to Sandra Castillo. Now, John Bitroff, who's already been convicted of killing 2 other women on Long Island, was long suspected to be Sandra's killer. But the question is, because you've got to focus on this area, are they looking at Sandra Castillo as a potential victim of the Long Island serial killer? Let's get back to more reporting from the New York Post. Authorities have also recently focused again on the area in Manorville. Remember, that's where the partial remains of 2 of the Gilgo Beach victims, Jessica Taylor and Valerie Mack, were found over 2 decades ago. It was unclear, though, if he's expected to be charged with 1 or both of those murders, sources said. Again, Gilgo Beach to Manorville is about 40 miles away. Jessica Taylor, Valerie Mack's torsos were found in Manorville, and then more remains were found years later on Gilgo Beach. So what is going on here? We need someone who's been in the middle of all this as an advocate for some of the victims here. The attorney representing the family of Shannan Gilbert, John Ray, is back with us. John, great to see you. Thank you so much for joining us tonight. First, your reaction to word that it looks like there may potentially be more charges against the accused Long Island serial killer. What are you thinking about tonight?
Well, you know, I've been the guard dog, so to speak, on this case or cases for many years now. And I count this as somewhat of a partial vindication of what I and the people working with me have said all along, that HEUERMANN could be the killer of all of them, all 11 of the people, now 12 when you add in Costilla. He's certainly capable of that. And I think one of the keys to why these bodies are where they are is hunting. You know, he's a hunter, and many hunters in the marshland hunting duck, many hunters in Manorville hunting deer, and he was a joiner. He belonged to clubs. There was a club for duck hunting even in Oak Beach. So there's a real chance that this is he's connected through that medium. But in any event, you know, it's a pleasure to know in an intellectual way only that finally there'll be some truth to the real nature of the killing of these poor young ladies. And I'm not sure, you know, we're all guessing right now what the DA is going to do on Thursday. You know, I'm hoping that that Karen Vergata is connected to, and Valerie Mack as well. But we'll see. You know, God knows what the DA is going to come up with. He hasn't leaked. So we wait. But people use the word closure for getting closure for some of these people, their families. There's no such thing as closure. Do you think when you lose your little baby, your little child, that things close because truth is discovered? No, you suffer pain. This brings back memories. This rubs in the salt. This is very painful for these people when they find out about this killer or these killers. And I don't think we're done by any stretch of the imagination. Nor do I think still that there was only one killer. You know, he could have been accompanied by other killers. He could have an accomplice or accomplices in the killings. It's an interesting fact that little toddler was wrapped in a blanket of some kind, which is something that a woman would do. Typically, not something you would see Rex HEUERMANN doing. So I think we'll find more and more connections to all of these other people. And that doesn't exclude Shannan Gilbert, by the way, at all. We have a witness who's come forward who had seen Shannan Gilbert with Rex HEUERMANN in the Sayville Motor Lodge. So he's not out of the woods literally on that case either.
So there was an additional search of his home. You know, everyone was camped out outside. Seemed like they were taking some boxes, some things out of there, focused, we believe, primarily in the basement area. What do you think is the significance there? Because I know in your investigation, you've uncovered some interesting facts connected to the home itself.
Yes, we did. And the witness that we had that came forward for being involved in a swingers incident with HEUERMANN in his home claims to have accompanied Karen Vergata to that home. And that when the witness was leaving with her detective, New York City detective boyfriend, who was part of the swingies event, Karen Vergata was in the window, the front window, with her hands on the window, showing fear, and then she ran outside naked in February. So it's interesting that the police removed the window, and I had somebody drive by there to check it, and they had removed it and it's boarded up. I don't know who else is connected to that window besides Vergata, you know. But of course, I don't know what the police are thinking. But there's another interesting event that occurred in that home when the police came in the second time recently, and that was that there was a book on the kitchen table, an alleged book anyway. It was a collection of photos put in a binder of a book that was published by a detective, a New York City detective years ago by the name of Jack Huddleston, and it contained ferocious, disgraceful pictures of the dead, one after the other after the other. There was almost no text, just sarcastic comments, and people who were cut in half, women who were chopped up, sex workers who were chopped up, babies who were dead, terrible, terrible things. And that book was, according to our sources, found on the kitchen table when they came in the second time. It was found on the kitchen table, and the daughter was home. The mother had left the night before. That book, which became an avant-garde book exchange, hard to get, by the way. I have it now, and it's disgusting to see. But that book is, you know, it's an avant-garde book for cults and cultish organizations. So why is it there? Why is it on the kitchen table? And we heard the lawyers for Mrs. Ellerup and her children saying, well, they don't know that any book was there. They didn't know about that. And anyway, it's not a crime to read a book. Well, nobody ever said it was a crime to read a book.
Yeah.
But there's something really, really wrong here.
Something going on.
That needs to be looked at separately. Yes, there is.
Absolutely. John Ray, always great to get your insight. And I'm sure after all the developments later this week, we will speak again. Thank you so much.
My pleasure.
When we come back, they're ready. Time to bring the think tank. Al Wunsch, Jennifer Brandt, Darnell Crosland, ready to get in on the Long Island serial killer case. On the next episode of Accomplice to Murder.
This was a multi-generational family plan to eliminate the patriarch.
Buried beneath a tomato patch. There they are. This is just 2 weeks ago. Back at the home of the accused Long Island serial killer, and they're seizing evidence 2 weeks ago. It's unreal. Well, now, like, the investigation is continuing. He's expected back in court. The New York Post reporting potentially more charges, more victims. But John Ray, who is connected to the victims in the case, nothing's confirmed. The DA has not said exactly what's going to happen. But let's bring in our think tank tonight, see what they have to say about all this. Joining us tonight, criminal defense attorney, former prosecutor Al Wunsch III. Also with us, criminal defense attorney Darnell Crosland and family law attorney Jennifer Brandt. Great to see everyone. Oh, we don't have Jennifer yet. Okay, we're working on Jennifer. Oh, by the way, I just have to mention Al. I know it's your mom's birthday coming up this week. Alda, 88. Fantastic. Congratulations. That's great, great news. But let's get to this case, Al. I'm trying to understand what's going on here. We're seizing evidence now? We're seizing evidence now. Do you expect more murder charges against the Long Island serial killer?
Well, there's a lot of bodies that are that they're not pinned to him yet, and I'm sure they're looking for that. And as they're going through these case files and they're looking through and they're seeing what they have and what they need and what they found, then they go back to the house and they see if they can match some stuff. It's not uncommon, especially in a case like this. And if I'm not mistaken, that Joel Rifkin was somewhat similar with regards to they were trying to piece him together with a number of killers and a number of bodies that had been found. And he was in the 90s, and now you're moving with HEUERMANN would be from the 90s into the 2000s. So it's not uncommon that the police would do something like this. It seems to me that they're going to be coming up with something, and it seems like there's going to be another charge. Now, of course, you've got, another 10 or 11 bodies out there that they don't have a person who did this. So it could be, it's a crapshoot as to who they're going to find.
Darnell Crossland, one of the things that happens a lot of times, I know this happened down in Florida with an accused serial killer down there, the Seminole count, I think it was Seminole. All the cases had to be tried separately, right? Like they don't try them all at once. What are your thoughts here about this? Because to me, if someone is an alleged serial killer, let prosecutors try the case that he is a serial killer, rather than, separating them one at a time. Let the jury get the full picture of who this guy is.
Well, Vinny, I know we've had these cases on Court TV, and you're all for trying them all at once, painting the man as a monster, letting the jury see that.
Have you seen him? Have you seen him, Darnell? I don't have to paint him. There he is.
Yes, absolutely. But there's this thing that's called presumption of innocence. And also the integrity of the system says that if something is going to be highly prejudicial against the defendant, we must avoid that. So although you title this gentleman as a serial killer, he's presumed innocent on each and every body that came before this court in terms of victims. So if the court feels that it'll be highly prejudicial to lump them all in, and for the jury to feel that lightning couldn't have struck twice in the same place, so he must be guilty, the court would try to avoid that conflict. And I think that's what's happening here. But in terms of why they went to his house, typically in cold cases, DNA type evidence, is harder to find later in life. But technology is so good these days that if they've gotten a tip about something and it involves DNA, they might just be able to find it even if it's 10 years later, because they're able to use a lot of different technologies these days.
Jennifer Brandt joining us. Great to see you, Jennifer. What do you expect to happen in court this week? Do you think it could be more than one more victim that they attempt to tie him to here?
Absolutely. I mean, there are a lot of bodies out there and a lot of people that there's no answer for. I mean, we don't know what happened to them. And here we have somebody who's already been charged 4 times, same location. It just seems that it's likely that he will be tied to the other bodies that are around the area. It just seems like his MO. So yes, I do expect that there'll be more, and searching his house, looking for DNA. I'm sure we're going to hear that there's going to be probably more than one additional murder that he's going to be tied to.
Rex Heuermann's got himself in a bad way, let me tell you. The article says that the New York architect charged in the Gilgo Beach killings will return to court this week after investigators searched his suburban home and combed a wooded area elsewhere on Long Island. Rex Heuermann, who was pleaded not guilty in the deaths of 4 women whose remains were found along a remote beach highway, will appear on Thursday in state court in Riverhead according to a spokesperson from the Suffolk County District Attorney's Office. He had previously been scheduled to return to court for a June 18th status hearing. The new court date comes 2 weeks after investigators returned to HEUERMANN's single-story home in Massapequa Park, where they had recovered a cache of weapons during an initial search following his arrest last summer. A date for HEUERMANN's trial has not been set. And during the most recent search, which lasted several days, investigators placed paint chips and other materials into evidence bags and removed a large rectangular object covered in a blue cloth. A spokesperson for the upcoming hearing was related to the renewed search effort. Now, guys, ooh, my goodness, my camera. Hang on. There we go. Now, as I started to say, last week when I touched on this, actually Julie Grant touched on it, and she said that maybe, just maybe, it could very well be time for Rex HEUERMANN to start considering a plea deal. Now, normally I'm not a fan of plea deals myself. I wrote my little editorial about it, but in this case, I'm starting to agree with her. I do have another update on Rex HEUERMANN a little later in this live stream, but as far as the hearing now goes, yeah, now would be a good time to start thinking about that. Let's move onward. We got a update on Ashley Benefield. And her attorneys were in court earlier this week for a motions hearing. And yeah, she's accused of murdering her estranged husband. So we're gonna take a look at that real quick. All right. Once again, I'm going to take myself off the screen.
Don't go out there, honey. Come on. I know.
September 27th, 2020, 28-year-old Ashley Benefield runs to a neighbor's house after shooting her estranged husband, Doug, in her bedroom.
She came in. She was quite hysterical. I didn't know who was banging on my door. Said that he attacked her, and she shot him.
Doug Benefield was 30 years older than Ashley and a widower when they met in 2016. They quickly married after a whirlwind 13-day courtship.
I first heard about Ashley. It was a Friday after school. The next day I met her, and then the following day, it was a Sunday, he told me that they were actually married, not just dating.
Ashley was a former ballerina, and she and Doug founded a ballet company in Charleston, South Carolina, to train and to showcase new talent.
He was completely in love, completely supportive, starstruck.
But by the end of 2017, the ballet company was bankrupt. She was pregnant, and their marriage was falling apart. Ashley left Charleston and moved to Florida to live with her mother because of her morning sickness.
I was unable to take care of myself in any way. I was bedridden.
Ashley was due in April of 2018. Doug had followed her to Florida, but she wasn't speaking to him. And he hired an attorney to try to help him find out if he could be with her for the birth.
To your knowledge, was Doug there?
No, he was not there. He had no idea. The baby was born.
After their daughter was born, Ashley filed an injunction to try to keep Doug from seeing her. She claimed he had a history of violent behavior and accused him of poisoning her and their unborn child.
I believe he tried to harm my child while I was pregnant with her, and that leads me to believe that if he would try to end her life or harm her while she was in utero.
The motion was denied, and the family court judge blasted Ashley's claims that Doug had poisoned her.
There is not a single scintilla of credible evidence that Miss Benefield has ever been poisoned or suffered from any illness of any poison.
Over the next 2 years, Ashley appealed the court's decision and continued making allegations of abuse against Doug. They were both ordered to undergo psychological evaluations, the results of which were scheduled to be released 3 days after Doug was killed.
It is the state's contention that the defendant did not want this report to come out. It was not positive towards her. Her goal was to move to Maryland and start over with DCF and the police up there, and maybe someone would believe her.
The day he was killed, Doug was at Ashley's home to help her pack up a U-Haul for her move to Maryland. He was unarmed when he was shot twice, once in the leg and once in the chest. Ashley says she was acting in self-defense after Doug body-checked her 2 times, hit her with a box, and grabbed her arm.
Given what she knew on that day about Douglas Benefield, boy, did she have every reason to fear him, especially after he refused to let her leave her own home.
Ashley Benefield is charged with second-degree murder and could be sentenced to up to life in prison if she's convicted.
The Black Swan murder trial, it will be happening soon. You will see it right here on Court TV. Let's talk about it. Al Wunsch, Darnell Cross, and Jennifer Brand, our think tank, still with us tonight. Darnell, she's claiming self-defense. She's claiming that he is the aggressor in all of this. She didn't do that well in family court. Judge didn't buy her story, didn't buy her testimony about being poisoned. Will a jury, you think, buy her story about being a victim?
It's kind of tough when you see a sort of a track record of self-help and it's connected to a goal. And that goal is to have that child with her and her only. And then everything else that you see that surrounds that goal is going to be looked at with, questioning eyes. So in the family court, the judge said there was no scintilla evidence that you ever poisoned. You didn't go to the hospital. You didn't have a history of anything medically that shows that you were poisoned. It sounds like you're just trying to support this goal of why you're here in family court. Then you take it over to criminal court, and what is he doing helping her move or pack or whatever? It sounds like she agreed to that so he can get over there and then she can carry out this murder. So nothing adds up, and if it didn't add up in family court, the burden is even higher in criminal court, and so I don't see the self-defense claim working.
Jennifer Brandt, we know things get heated when a couple is breaking up. We know they get more heated when they're fighting over the custody of a young child. And in this case, you had a woman who left where they lived and went to go live with her mom. Now, obviously, it seems there's probably be 2 versions of why all this is happening. Who is the dangerous one? Who isn't the dangerous one? Let me ask you, from your experience in family courts, how difficult is it in these situations to uncover the truth of, who, we saw it in the Johnny Depp Amber Heard case, right? We saw how that all played out. This is sort of a similar scenario that turns deadly in that there was obvious problems between these two, but how tough is it to figure out who's the aggressor, who is the dangerous one, and who isn't?
Very tough, Vinny, because it is a he said, she said. You know, you don't have a lot of third-party witnesses often in these types of cases because it involves a time period, of what went on in the relationship and, different events that may have occurred. It's not just one single event necessarily. But I think what hurts her here are the claims that she made in family court about him poisoning her and the fact that the judge found that there was no evidence whatsoever to support her claim. So it makes anything she says now come into question, including the self-defense claim that she's raising as the reason why she shot him. you know, without that, without the issue of the poisoning, then maybe, you know, she would have a bit more credibility, because she did have some bruising on her, or scratches or whatever. But the fact that she tried this once, tried to get him away from the child, and then comes up with this self-defense claim, I just think it sounds pretty weak. I think she wanted to have that child. I agree with Darnell, and she didn't want him part of her life. And that happens very frequently in family court. You know, one party just doesn't want anything to do with the other one and doesn't want them to share custody of the child. So that's pretty common.
Al, the closest we have to an eyewitness to this is the neighbor who called 911. So he doesn't see what actually happened, but he's there in the immediate aftermath of all of it. And it's clear to me that he is very sympathetic towards Ashley Benefield, the defendant here. My guess is the defense will likely call him as a witness. Prosecution may call him as a witness. He called 911. But how important is the 911 neighbor to all of this? Someone who's living next door to them, who, again, very sympathetic to the defendant in this case.
Well, see, the problem is like, I don't think he has any firsthand knowledge of anything. And I think, quite candidly, he's taking what she says and then going forward with it. I mean, you can hear her kind of hysterical and things along those lines. And then he throws out that comment, well, they've been having problems, I'm maybe paraphrasing it, or they've been having trouble or something along those lines. And we don't know where he gets that from. We don't know if he saw that or that's what she told him. So I don't know how good of a witness he's going to be, other than the fact that she came over there hysterical and this, that, the other thing. But as I remember, the Menendez brothers did a pretty good job of being hysterical on the phone and screaming and yelling and everything along those lines. And they were convicted of the murder of their parents. So I'm not sure that he really adds anything to this case. And like, you know, what was mentioned before, you know, by Jennifer and Darnell, I mean, the hurdle to get over to convict someone in domestic violence courts is preponderance of the evidence. And the judge found that she didn't even have a scintilla of evidence. So the credibility is zero. I mean, a scintilla is the smallest, slightest amount of credibility, and she didn't even have that. So I think it's going to be a very big uphill battle for her as a defendant in this case. And obviously she's going to have to take the stand. And if she couldn't convince the domestic violence judge that there was a case here, I think she's going to have a hard time with the jury.
Well, let me ask you this, Darnell. We only have about 30 seconds here. Being a swimsuit model and a ballerina, is that an advantage or a disadvantage when you're sitting in the courtroom as an accused murderer?
Well, there was one judge in the Bronx Criminal Court that during the jury selection, the defense attorney was striking a lot of people, and then this beautiful woman came up, and the judge leaned over to both of them and said, if anyone strikes her, they're going to have a problem with me. So I think it's an advantage. It helps the day go by quicker.
All right. Stay where you are. When we come back, we're going to take you into family court and what happened there and what happened today at a hearing involving some evidence. Should it come in? Should it not come in?
I had to jump in real quick regarding this, and I gotta agree with Vinnie Politan, the think tank. By the way, my thanks to them and this for covering this case. The moment that you can't provide a scintilla of evidence to back up your claims, I don't care if it's small claims court, civil court, or criminal court. The moment that doesn't happen, your credibility is gone. I'm talking about you make the claims all you want to, and this will likely be the sound you get. That's how much credit. That's how bad your credibility is shot. All right. So now I'm gonna step away from this screen once again, and we're gonna take you to the heated moments in the custody hearing. Ashley Benefield and her estranged.
One of the most successful true crime TV shows.
Friday nights, the WNBA.
There he is, Neil Taylor, a really good attorney representing the so-called Black Swan, Ashley Benefield. She's been charged with murder, and he's trying to keep some evidence out of the case. It's pretty normal. Motion to suppress some of the evidence, keep it out. Motion to eliminate, can't have it. So one of the big pieces of evidence is really just a scintilla of evidence, a ruling by the judge that there was not one scintilla of evidence of this alleged poisoning. Let's take a listen to that ruling, which was made in the family court matter.
This court will find that as far as credibility is concerned, I would find, and I'm going to say this in the gentlest form I possibly can, that there is absolutely not a single scintilla of credibility that I'm attaching to anything that was testified to, at least in this hearing of Ms. Benefield.
Ouch. Ouch. So obviously the defense does not want the recording of this hearing in front of the jury in the murder trial and was arguing against it today.
This is a recording that takes place, Judge White, 2 years before the actual homicide. And in a nutshell, Your Honor, they've advanced this theory by weaving innuendo and inference, and you just cannot make a fact out of that, Your Honor. So with no respect for the magnitude of the leap, the state basically says, well, when Ashley Benefield heard Judge Moreland opine about her credibility, that was when she decided to kill Douglas Benefield. That's a pretty high leap from going to having to share custody with a child to deciding to kill the spouse. We're basically saying to the jurors, here is the opinion of the chief judge of this circuit, who has concluded that Ashley Benefield, under no circumstances, has one scintilla of credibility, that she would not believe anything Ashley Benefield has to say. Ladies and gentlemen, you don't have to attach any significance to that other than the impact that it had on Ashley Benefield. The problem with that is they're hearing the opinion of the chief judge that sits in this circuit. And the case law is replete with references to the influence that such a statement from a judge would have, much less the chief judge.
Jennifer Brandt, it would be very beneficial to the prosecution. What do you think? Is it fair for the jury to hear that a judge who listened to her testify found that there was not one scintilla of credibility to her story about being poisoned?
I do, because I think it's about the claim that she was advancing. The fact that, you know, Doug had poisoned her and he was, you know, be kept away from her and tried to harm her and their unborn child at the time. So I think it's all very related to what is going on here and the claims made in this case, in the criminal case. So I do think it's important for the jury to understand that another judge totally rejected her claims and that she was clearly trying to build a case against him, trying to show that he was, you know, a bad guy and was out to hurt her and he should have no contact with their child because of that. So I do think it's very relevant in this case because it shows why, you know, maybe why she's being charged and why she might be found guilty of the crime that she's charged with, you know, that she actually shot him just to get rid of him as opposed to self-defense.
Al, how do you think this plays during the trial? Does it get played during the trial?
I think it has to get played. False in one, false in all. And under these circumstances, I mean, she made some very serious allegations against him. One, that not only he was poisoning her, but he also poisoned his wife, and that she ended up dying as a result of what he did.
His first wife.
His first wife. The first wife, right?
Yeah.
The first wife. And that the police investigated that, and it turned out it was not credible, and that it was not accurate, and it wasn't true. So, you know, the fact that she has gone this route, and then the fact that the kid is born basically isolated from him, doesn't put his name on the birth certificate, everything along those lines, just shows that she has a plan. She wants him out of the picture. And it progressed. If I can't get him out by accusing him of murder, attempted murder, or anything along those lines, then I have to go to the next level, which is self-defense. I'll kill him. Simple.
Darnell, I want you to take a listen to testimony from a psychologist who evaluated Ashley Benefield. And this, again, is something that the defense wants excluded from the murder trial.
She made it very clear on more than one occasion that she had no intention of reconciling with Doug, and that she had every intention of relocating to Maryland with her mother, and particularly because her grandmother had passed away and her mother had inherited that home so she could return to her native home state of Maryland.
And did she indicate to you that she was going to go without Doug? Go to Maryland without Doug?
Again, in several different occasions, she had indicated that was her intention. She did not want him to come along with her. There was some email exchanges indicating that she was trying to make that happen. He made it clear that he was going to be going there and thought that he'd be moving in with them, which she clearly made clear to me that that was not going to happen.
Okay. So she made clear to you that he is not moving in, we are not getting back together.
Yeah, absolutely.
Did she say those things and act that way during the joint session with Doug?
No.
Okay, Darnell, so should the jury hear this? Should the jury not hear it? And again, the theory of the prosecution is that she was telling Doug that they were going to reconcile, and that's why he's with her and trying to get that done, when really having no intention to ever reconcile with him.
Well, yeah, so there's a distinction between this and the idea that a judge made a determination in another hearing dealing with other issues versus here. So in this particular evidence, I would say, yes, this can come in, because as legal scholars, we have to ask ourselves, why are we letting something in? Why are we talking about this? In this particular case, it goes directly to motive. So if obviously she's trying to claim they were getting together, they were trying to reconcile, and then she's claiming that's when this meeting took place and she killed him because he tried to hurt her. That's evidence. Whether you believe it or not, that's evidence. In the other situation that we talked about, relevant evidence is important. Evidence having a tendency to make the existence of a fact that's in consequence more probable than not. Judges get appealed all the time for making wrong decisions. Now, it might be helpful, but it's not relevant, and it's not relevant evidence. A judge's conclusion is not evidence, and a jury should be able to listen to something de novo and not have to listen to something already concluded by another court and say, okay, the other court said it, so it's true. So I don't think it's false for one, false for all in many instances. You have to take them separately.
Let me ask you, Jennifer Brandt, when it comes down, it's self-defense. I believe she's going to have to testify in this one. In terms of jurors, men versus women, with the swimsuit model ballerina on trial, how does that play?
Yeah, I think she wants a bunch of men on that jury, because they may feel sorry for her. They may feel that, you know, she's beautiful and innocent, and she was much younger than he was. And that she was just being, you know, he was harming her, and she had to defend herself, and that's why she shot him. I think she has a much better chance with men on the jury than women. Women will be more skeptical of her and probably say, you know, they would not necessarily believe what she has to say. But
Al, do you concur?
I don't actually. I think men are going to be very critical of a woman taking their daughter away from them. And I think that men are going to look at that and say, wait a minute, why did that happen? And that I would do anything to stay with my child. And that she stood between them and tried to alienate him out of the picture. But he didn't see the baby for 6 months after the baby was born. And I think a man that is sitting on the jury is going to look at that and say, there's something wrong here. There's something that doesn't click quite right, and that it's going to come back and backfire on her. I think she's got a better shot with women on the jury.
Darnell, you have 5 seconds.
Yeah, my experience supports Jennifer because men typically are rescuers, and women are typically more critical. In the sexual assault cases, you find that. So I'm going to go 2-1. Jen and I, we win. Al loses.
There you go. Al Wunsch, Darnell Crossland, Jennifer Brandt. That's all the time we have. We'll see you next time.
I'm gonna have to go with the two with the two who actually said that the jury may find a little bit more sympathy for most of them who are men, that is, in this case, because I mean, look at everything she's charged with. Lawyers for Ashley Benefield asked a judge on Monday to exclude evidence from her second-degree murder trial, certain details from her child custody battle with her estranged husband, including a judge's ruling that called into question her credibility. Her credibility is already shot. Her credibility is already shot. So, what are you expecting here? Here. I mean, the chances of whatever evidence is gonna come out is gonna come out. That's you can bet on that. Presiding Judge Matt White will issue rulings on these and other motions argued, and including a request to prevent prosecutors from showing Benefield's mugshot to the jury. Honestly, Ashley Benefield looks like her case is already dead in the water before we even get to a trial date. But we'll see what happens. All right, the first a couple new cases that's gone to trial, and I believe that trial is already underway. This is Florida versus Wade Wilson in the strangled women murder trial. Let's see. Wade Wilson is a Florida man facing the death penalty if he's convicted of murdering 2 women. Wilson is charged in the 2019 deaths of 35-year-old Christine Melton and 43-year-old Diane Ruiz. Melton was found dead in her Cape Coral home on October 7th. That same day, Ruiz vanished while walking to work. Her body was found 3 days later in a field behind a Sam's Club. In November 2019, Wilson was indicted on multiple charges, including 2 counts of first-degree premeditated murder. Court documents accuse Wilson of strangling the women to death. At the time of the indictment, Wilson was already in custody on unrelated battery charges. He was hit with additional charges on October 2020 after he and another inmate allegedly tried to escape jail. While awaiting trial, Wilson's contacted Scripps News Fort Myers multiple times in 2020. He told them that he used to be connected to a high-level human trafficking ring and that he would groom women for them. Wilson claimed the group was framing him for the murders as punishment for trying to leave. In a pretrial motion, Wilson asked the court for facial makeup to cover up his tattoos. That might be objectionable to members of the potential jury pool, and the judges granted his request. Opening statements are scheduled to begin Monday, June 10. Let me take you right to Julia Janae for more.
We are turning our attention now to Florida. Day 2 of jury selection in our newest live trial, the Strangled Woman murder trial. The defendant is 29-year-old Wade Wilson. He faces multiple charges, including 2 counts of first-degree murder in the deaths of Christine Melton and Diane Ruiz. These 2 women were killed within days of each other back in October of 2019. Melton was found dead in her home, and Ruiz was found in a field several days later. Wilson faces the death penalty there in Florida in connection to these killings. For more on jury selection in this trial for Wade Wilson, here's Scripps News affiliate WFTX in South Florida.
I'm Fox 4 senior reporter KAITLYN Knapp, keeping you up to date on the first day of a high-profile Cape Coral double murder trial. Wade Wilson is accused of killing 2 women in 2019, Christine Melton and Diane Ruiz.
You've all been called for jury service in the case of the state of Florida versus Wade Wilson.
And with those words, Wade Wilson's trial began. He faces 6 charges, 2 counts of murder for the strangulation of Christine Melton and Diane Ruiz, grand theft of a motor vehicle, battery, burglary, and petty theft. Charges the judge read to Wilson in court.
Did unlawfully from a premeditated design to
He showed no emotion on his face, though Wilson did fold his arms and lean back at times as his attorneys and the prosecution questioned potential jurors.
Do you have any personal or moral or religious opposition to the death penalty?
Both sides asked that because if Wilson's found guilty, he could be sentenced to death.
Even if you find that the aggravating factors outweigh the mitigating circumstances, do you understand that the law will never compel you to come back with a recommendation for death?
The attorneys also asked about the tattoos on Wilson's face. You can see a line by his mouth mimicking stitches, a swastika on his face, and many other tattoos.
Is there anything about his face that would cause you just to say, oh, he's guilty, or would you be able to say, I'm going to listen to the evidence and make the state prove the charges beyond a reasonable doubt?
The judge ruled Wilson can wear makeup to try to cover up the tattoos, but he did not appear to have any on the first day of the trial. Again, jury selection will take about a week, and then the trial is expected to be another 2 or 3 days, and I'll be here every step of the way. Reporting inside the Lee County Courthouse, KAITLYN Knapp, Fox 4.
Still with us to discuss this new live trial on Court TV, criminal defense attorney and former prosecutor Marie Pereira is with us, and family and parenting relationship expert Dr. Sue Kornbluth is with us as well. Marie, let me start with you. Your thoughts on this ruling by the judge saying that he can wear makeup in this case. It's one of those unique rulings, but seems to be important in a case like this.
Absolutely, because it will work in his favor if he chooses to do it. But just looking at him, just that a person could put all of those tattoos, he looks like something evil. And he knew what he was doing because he got the tattoos. So would he even know that it's in his best interest to even cover it up? And the trial started, he's got it on. This is not going to help him. He looks creepy, scary, and he looks like somebody that has a propensity for violence, just off the strength of what his face is like.
Dr. Sue, you were reacting when we saw those images and the decision by the judge, but your thoughts from a psychology perspective on perhaps what you would recommend if you were someone who was on this defense team, consulting with them and making suggestions about perhaps this death penalty case.
Well, I think Marie was correct when she said that he has all these tattoos all over his face. They are hate tattoos, a lot of them, which doesn't make him look very good to the jury. And these are hate crimes, too, all right? Anytime a woman is killed, raped, they're hate crimes. They have something against women. What I would suggest psychologically is to go back into his background and paint a picture that he was an abused child or he had mental health issues or anything along that line to create some kind of sympathy for this young man. But I don't think there's going to be any. When you wear swastikas on your face or hate messages, the jury is not going to look at that very fairly.
Now, Marie, he's not charged with a hate crime, but in Florida, he is facing the death penalty. So there's nothing that could enhance what he is facing in this case. Your thoughts on that process when we're asking the jury those questions about whether or not they can be fair and impartial, and they also have to be asked, can they find for the death penalty? Because it can't be someone who is completely against the death penalty. Do you agree with that process that's happening there in Florida?
It has to be a process because you want to pick a jury of the person's peers who are capable of following the law. And if this is a death penalty case, they have to understand aggravating factors. And if they are proven, then the next phase of sentencing will come. Are you able to morally, ethically, spiritually say this person will be put to death if the state proves all the aggravating factors and there are not enough mitigating factors when the sentencing phase comes? So yes, this is very important. We don't know all the details of the case, but 2 women were murdered, and they were, you know, one frail woman, 2 frail women against 1 evil-looking man. So it's starting out at the gate like this is a death penalty case, and they're trying to make sure they pick the right jury to do that.
And Marie, my follow-up is, because it's death penalty, we know there's going to be aggravators and mitigators that are going to, if he's convicted, they won't go to that phase if he is not convicted of these 2 murders, but if they get to that phase, the state will be saying aggravators, and one of those is atrocious and heinous, but also that these were 2 victims on separate occasions. Do you think that is a relevant aggravator when you have 2 women who were not together? And we don't know yet about his relationship between either of these women, but do you think there's one that's more aggravating than the other, if he knew them or if this was random?
Whether he knew them or not, or it was random, you're talking about the lives of 2 innocent women, unprovoked, he murdered. So that's a cruel, heinous disregard for human life. It shows a propensity for violence. And then he has prior history too, to my understanding, of contact with the criminal justice system. And there was no purpose for the murders, except random. Even if there was a purpose, we're talking about the heinous taking of 2 lives for no reason, unprovoked whatsoever. So the aggravators are there.
I forgot to hit the mute button and put myself back on the screen. I mentioned that we'll see what becomes of Wade Wilson when opening statements begin on June 10th, which is Monday. Moving on to this case, this one bugs me a lot. The abuse and subsequent death of Kinsley Welty. We're gonna go right to Court TV's coverage via YouTube.
The abuse was only towards Kinsley?
The neglect was them all, but
the neglect,
the physical abuse was Kinsley. It wasn't about she didn't want her. She wanted to see Kinsley dead. That was her goal.
As one grandmother is pleading for justice, another one is facing some new upgraded charges this morning. We're shining a spotlight on the tragic death of 5-year-old Kinsley Welty. Tammy Halsey, the maternal grandmother of Kinsley, is now facing 5 counts of child neglect and 1 count of failing to report child abuse or neglect, all in connection to Kinsley's death from malnutrition. The probable cause affidavit filed in late May includes some Facebook messages between Halsey and TONI McCLURE, who's Kinsley's mother. Messages that reveal Halsey's alleged participation in the abuse of Kinsley. Now, Kinsley was found covered in feces and bugs crawling on her head and her face. She weighed more as a 2.5-year-old than she did as a 5-year-old. I want to bring in my guest and talk about this. Still with me, psychologist Dr. Sue Kornbluth and criminal defense attorney and former prosecutor Franz Borghardt. I want to show you both some of these messages that police obtained between grandma and mom. So here we go. Tammy Halsey, it's the no sleep and have to work on Monday. Do your duct tape thing. Sleep. I won't ask again. Let's keep going there. Then in September, Kinsley has damn near got that door pushed open. And then grandma responds, tape her ass down. Oh, that's lovely. Let's listen to some more. Kinsley broke the lock on the door and the, bad word was in her pants. She shoved under the couch. Tie her expletive ass up. This is sickening. Just sickening. Mom, and grandma. 2 people are supposed to love this child. Dr. Sue, go right ahead, please.
I'm sick as you are over this case. I was when it broke. When I learned that the grandmother was involved, it even made me sicker. But look, apples don't fall far from the tree. And I believe TONI, who is her daughter, learned this kind of abuse from her mother, who is the grandmother. And it's clear as day that they were in this together, telling her to duct tape her to the bed. And I believe the grandmother even did that, Julie, when she was watching her. This evidence is extremely damaging. These 2 individuals are extremely mentally ill. And the grandmother, in my opinion, belongs in jail.
I'm with you. And there's a legal aspect to this too, pertaining to grandma, because she thought about getting some help for Kinsley. Franz, I want to go to you on this. I want to show you what we pulled from the probable cause affidavit. Tammy is saying she thought about calling the police or getting Kinsley some medical attention, but never did, because she didn't want her daughter to lose custody of her other kids. Franz, I can't with this. Your thoughts?
So this is just, it's crazy, right? Like who duct tapes kids down, let alone who messages in a casual manner doing it. It's insane. Now, here's the question. Does grandma have less culpability because it's not her biological child? I'm not saying that's her defense. I'm just saying at some point, do these 2 point the finger at each other? Does daughter say, look, I learned it from watching her. It's not an excuse, but maybe it's somewhat of a mitigator, because again, like the good doctor said, the apple doesn't fall far from the tree. I just don't know that either of these guys are gonna get any kind of quarter, and I agree. I think they're going to end up in jail with extended sentences.
Let's take another look at the probable cause affidavit. This pertains to mom here. So apparently that she knew she had failed Kinsley. She knew she had done the bare minimum
stated that she knew that everything she had done to Kinsley was wrong. And Child Services was involved. This case was on their radar. And what stuns me perhaps the most about all this, they were at the house the day she died. Dr. Sue, what do you think when you hear this?
Julie, it's appalling that you can go into a home and then leave knowing, we think, that abuse has been going on. They were called to the home many times before that. You know, and we keep hearing, right, that Department of Human Services is understaffed and underpaid. Pay them more.
Right.
But it's not an excuse for not doing your job and your due diligence to protect these children. It happens over and over and over again, and it can be prevented, I believe.
Right. Oh, I'm with you, my friend. We have prosecuting attorney Ryan Mears, who's handling this case. He was kind enough to come on opening statements before. He's going to be on again on Friday, by the way. Let's take a look at what he told us back in April about DCS.
In this particular case, unfortunately, this was a family that was not a stranger to DCS, who had multiple interactions with DCS. It wasn't just the day that she passed away. There were numerous other opportunities where people could have seen and really been able to take a look at the condition that Kinsley was in. I think the thing that stands out to us is this is something that happened over a prolonged period of time. You don't die from malnourishment and dehydration overnight. This takes some time. And there were multiple intervention points where if people had seen the child, they would have very clearly been able to observe that she was suffering.
Ryan Mears knows what's right here. And Franz, I want to go to you on that point. You've been a prosecuting attorney, and I think something that needs to be made clear. Just because prosecutors and DCS workers both work for the government and are employed by the government, the various counties, doesn't mean they're in agreement, on the same team. Often as a prosecutor, you feel like you are totally alone when you get a case like this, like Ryan has. Would you speak to that, please, Franz?
Well, not only are they not on the same team, DCFS, Department of Child Services, can be prosecuted for negligence.
Yep. Right. Great
and
point.
in our look, hanging out on court TV like we do, we've seen people prosecuted for negligent-based homicides for not doing an obligation or a duty, or for doing something that should have been a duty. Guys, I cannot believe there's not a third defendant in this one, and that's Child Services. I think you can prosecute the caseworker for failing to step in. No, they shouldn't have the same level of culpability, but man, oh man, this seems like the case, right?
Yes, excellent point. Franz Borghardt, thank you for that. We've got to leave it there, but stay tuned for that. Maybe that's something we're seeing, and Franz called it first. And Franz, we got to say goodbye to you, let you get off to court. Thank you so much for everything. This Sue's coming with us. When we come, we're revisiting this case. I want to let you know something. We're revisiting this case on Friday, as I mentioned. The lead prosecutor is going to be joining me live here on Opening Statements as we continue on this show to be a voice for victims. That is our goal right here, as you know, my friends.
Okay, I gotta say something right now. I gotta speak my piece on this case. First of all, to do what these women are being alleged that they did to a child. Like I said once before, that's only a parent and a grandparent in name only. Come on. Who abuses a child like that? Who dares to you need to get some sleep. The child's hungry. So what do you do? Mom tells her mom to do the duct tape thing. Are you serious? I don't know how many times I gotta say it, but I'm saying it again. You got one job. One! And both of you failed. You both failed that it's so bad a child is dead. And you two, along with Ryan, you're the cause of it. Whatever, because I'm telling you now, this is the summer of justice. Your time comes, and you go to trial. You're found guilty. Whatever sentence they give you behind prison bars, in this guy's opinion, it will not be enough. That child is already serving a life sentence of not being on this earth anymore. On the one side, it's bad because she never had a decent chance to live. On the other side of it, it's good because she'll never have to suffer here. But like I said, Toni McCLURE, Tammy Halsey, whatever sentence you two get hit with, I promise you, it will not be enough. All right, next up. Next up, prosecutors want the convicted Hannah Gutierrez to testify against Alec Baldwin in the Rush shooting case. Prosecutors are trying to force Hannah Gutierrez to testify at Alec Baldwin's upcoming trial, according to her attorney, who publicly broke the news on stage at a true crime convention in Nashville. Days later, New Mexico's special prosecutors Kerry T. Morrissey and Erlinda O. Johnson filed a motion to grant Gutierrez, who was listed as a defense witness, use of immunity. On Friday, the Honorable Mary Marlowe Summer scheduled a hearing on June 21st over the issue in Baldwin's case. Now, the former Russ set armorer is serving an 18-month sentence after she was convicted of involuntary manslaughter for her role in supplying the loaded gun Baldwin was holding when he shot and killed cinematographer Helena Hutchins and wounded director Joel Souza. Jason Bowles, who represented Gutierrez in her trial, joined Court TV anchor and former prosecutor Julie Grant and Court TV legal correspondent Matt Johnson at CrimeCon 2024 to discuss Gutierrez's trial and how it can impact Baldwin's trial. So I'm gonna cut myself out again, and I'm gonna let you, before I go into that video, here's your trigger warning, and here's the disclaimer. And now, here we go.
I think the code of the thing, the camera's there. I believe, my recollection is she was there, turned a bit, like talking to him. So I think she was hit in the right armpit. But this is all I know, and that is that I take the gun out in the rehearsal. Really, he wanted very dramatic and very sort of kind of sneak up on them. I take the gun out, and as I take it, as it clears, as the barrel clears the hole, I turn and cock the gun over here. I turn and cock the gun goes off. It's supposed to be a cold gun. Nothing. No flash charges, nothing.
Well, the gun didn't just go off. Like, you have to do something to a gun for it to fire. And I think from the beginning, Alec Baldwin said, my finger wasn't on the trigger. So that may be a point of contention. His trial is scheduled to come up next month, Alec Baldwin. And it's a homicide. If he's found guilty, he'll likely go to at least jail. There's always a chance that there could be a plea deal last minute, but I don't know if Alec Baldwin would ever admit to a crime. I mean, from the beginning, he is pointing the finger in other directions, always away from himself. But 2 other people have been convicted. 2 other people that touched the gun. The armorer, the assistant director, and he's the one who had the gun in his hand when it went off and killed Helena Hutchins. So the big question that I have anytime I talk to this story to anyone is like, well, why on earth was there a live round on set? And where on earth did it come from? Why would anyone bring a live round to a movie set? There's no reason for a live round to be anywhere near a movie set. And I think that's the shocking part for people. Well, we saw the trial of Hannah Gutierrez, the armor, here on Court TV. And we've seen some of the photos, some of the evidence. Right here you have, there was a live round that was found in a dummy ammo box. Now, the dummy rounds are the ones that look like live rounds, almost look like a live round. They don't, blanks look much different than dummies and live rounds. Live rounds and dummies look very similar, and the blanks look much different. And in this case, there's one that was in a dummy box, a live round. You can see the slight differences in if there's an indentation. But really, what we learned in the trial is you got to pick it up and shake it. You shake it to each one individually to see if it's a live round or a dummy. There was also apparently a live round found on Alec Baldwin's ammo belt that he's wearing. And that's what you're looking at here. So the live round that was in the gun apparently wasn't the only one. So where did these live rounds come from? Well, Hannah Gutierrez spoke to investigators, as everyone did, after the tragic death of Helena Hutchins. And here's what she said in one of her police interviews.
How would you say that a live round got in this box that you pulled from?
I'm not entirely sure if someone put a live round into that box or not. I checked those to the best of my abilities. I was walking in, shaking it in my ear, and I thought I heard it shake for sure.
When do you think somebody would have had the opportunity to put a live round?
You know, it's hard to speculate on that exactly, but, you know, that gun, it was on Alex most of the day, and then also it was on top of our cart sometimes too, and there were times when I was gone to the bathroom, you know, and like I said, I gotta pee, you know. And I tell the girls to watch the cart and everything, but sometimes the girls get distracted by the actors.
This was a question that really wasn't answered at Hannah Gutierrez's trial. But at the end of it, I was like, I still don't know. Like, there's potential theories out there, but how did this live round get there? So I want to bring in a guest who knows a lot more than I do about all this. Our special guest, the attorney who represents Hannah Gutierrez, Jason Bowles, is with us. Jason, thank you so much for joining us tonight. I really appreciate it.
I appreciate you having me on. Thank you.
Okay, so where did these live rounds come from? I mean, a live round should not be anywhere near a movie set. I think everyone agrees with that. So this is still a mystery to me. What do you have a theory?
We have a theory. It's still a mystery because the state never fully investigated it. Here's the problem, Vay. This was the biggest question at the outset of the case in the case. And early on, the DA called it a red herring. So the sheriff did not fully investigate it. Now, they did a search warrant at PDQ Props. The search warrant laid out that these reloaded live rounds began with Joe Swanson. They then went to Troy Teskey, Thel Reed. Then they went to the 1883 set where Thel Reed and Seth Kenney had them to train actors offside on the set. After the 1883 set, which was before the Rust movie, Seth Kenney took possession of those reloaded 45 long cold rounds. So at that point, we know that the primary supplier to the Rust film had the 45 long cold live rounds. We also know he returned to New Mexico on October 12th. and he said that he supplied the set a new box of dummy 45 long Colt ammunition. October 12th is about the time the prosecutor says these pictures began showing live rounds on the set. Now, here's the problem. The sheriff never did DNA testing. They never did fingerprint testing on those live rounds. So they never ran that down. After the search warrant at PDQ Props, they then dropped that whole line of inquiry and didn't investigate it further. So we have an opportunity now, and we have a new piece of evidence that's been turned over to the sheriff's office, and to date, they haven't looked at it. And that is Troy Teske, who is a magistrate judge, very credible individual, and the picture is on the screen now. These are the rounds that he had from the same batch. Now you can see there are 5 of them with silver primers. Those 5 silver primers, I believe, match what was found, the live rounds on the set of Rust. Those rounds, Troy Teske, again, he was a longtime police officer in Bled City, magistrate judge, very credible. He turned those over to the sheriff the last day of Hannah's trial. And he said, here are rounds from the same batch. These need to be tested by the FBI. They need to see if they match the live rounds on set. And then we can connect those, as I've said, through the chain that I talked about. But once again, Benny, they have not done this step in the investigation. That's what we're dealing with.
Okay, so let's break this down for folks. So a lot of names thrown out there. I know you know the case inside out. So Troy Teske is a man, that's the photo we're looking at. And what you're saying is those live rounds that he has, why does he have these live rounds first?
He was storing those for Thel Reed, and these were Thel Reeds that he had from Joe Swanson. And these are rounds that they use to either just shoot or to train actors off-set on shooting.
Okay, so he's holding these, and the question is, the rounds that are there, the ones with the silver primer, are they the same, from the same batch as the one that struck and killed Helena Hutchins? That's the, and that can
Absolutely.
be, you believe that can be forensically determined?
I believe it can. They're from the same batch. I believe the FBI has the capability to test the powder, and not just whether it's single base or double base like they did at trial, but test what type of powder is in it. Is it Trail Boss? What type of powder is used in them? That way they can match. Were these created by Joe Swanson? Were they reloaded by him? Did they go through Thel Reed and Troy Teske and get to Seth Kinney? That's the investigation that needs to be done now to connect these up.
Okay, so if this theory pans out, if everything you're saying turns out to be true, how does it then get onto the set of Rust and into Alec Baldwin's gun?
Well, Seth Kinney testified at trial on October 12th. He delivered a new box of 45 long Colt dummies. Now, he said they were dummies. He said he shook them all, but he's got 45 long Colt in his possession that are live as well. Now, we saw pictures in the trial from his shop, his office, and I wouldn't call that the paragon of order. It was complete disarray. So I do not know exactly how they got there, but my theory is these came on through negligence or accident in that box. And it's just never been tested. It's never been connected up because they didn't want to. They had an easy target in Hannah, and that's what they wanted to do.
So if these other people are involved in the chain of providing live rounds in a box that is marked dummy rounds, and they're the ones to deliver it, what does that mean towards Hannah Gutierrez and Alec Baldwin? Does that absolve them of their role, or does it just add more people who should be held responsible for this?
I think that's an incredibly good question. And the question is, as a prosecutor, are you going to charge everybody? Are you going to say everybody committed a crime here? Or are you going to say this is a tragic accident caused by a number of mistakes of numerous people? And that's what I think it was. I think it was a tragic accident. Even get to Baldwin. Mr. Baldwin, then, he didn't know that there were live rounds in that firearm. There's not a person on that set that knew there were live rounds. The prosecutor said that. You don't have to take my word for it. So we're dealing with a situation where people make mistakes, and that's a civil case. That's a lawsuit. That is not a reckless case of criminal liability. A reckless case is a much higher standard.
So in tracing where the live round came from, are people talking at all? Because you mentioned a lot of names. Are these people talking? Are they avoiding? Is anyone taking responsibility? Are people cooperating? Or are people trying to shoo you away and shoo everyone away from figuring out? Because I'm with you. That was the first question and probably the most important question. How does a live round get on a movie set, on a Western, where there are rounds everywhere and every actor is carrying guns and holding guns and pretending to fire guns?
Absolutely, Vinny. It is the most important question. And you have to answer that to get to the truth, to get to what really happened. If we're going to do justice for the whole case, you got to answer that question. So to answer your other question, yes, Del Reed's willing to talk. Troy Teskey's willing to talk. They have been from day one. The sheriff has never wanted to have them. The prosecutors never wanted to have their story. So they haven't followed up on it. Troy Teskey offered those rounds that you showed earlier in the picture, offered them up to the state and said, come get them. I've got them. Well, finally, he brought them to Hannah's trial. Nobody wanted them. So finally, he took them to the sheriff at the end of the trial. Because I'm going to say again, I don't think they wanted to get to the full truth, which is what we're all trying to do, to have justice in the case. But they didn't want to do that because Hannah was an easy target. And again, if you're trying to prosecute Mr. Baldwin for what I do not believe is a crime, a reckless standard is somebody gets drunk, gets behind the wheel. They know that if they hurt somebody, they knew what they were doing. That's not what happened. Nobody knew there was a live round on that set or in that firearm. Mr. Baldwin didn't commit a crime either. But let's get to the truth and find out what really happened. That's what we've been begging them to do for 2 years.
All right, Jason Bowles going to stay with us. Up next. Will Hannah Gutierrez have to testify against Alec Baldwin in his trial? We'll break it down.
One of the most successful true crime TV shows.
Ready for the day's proceeding. Plus, deeper dives
on Court TV.
My heart goes out to the film industry for the devastating pain that this tragedy caused and the old wounds that have been reopened. I am saddened by the way the media sensationalized our traumatic tragedy and portrayed me as a complete monster, which has actually been the total opposite of what's been in my heart. Your Honor, when I took on Rust, I was young and I was naive, but I took my job as seriously as I knew how to. Despite not having proper time, resources, and staffing, when things got tough, I just did my best to handle it.
Hannah Gutierrez was convicted, sentenced to 18 months. And I think that's what Alec Baldwin is looking at as he gets ready for his trial next month. But in a very interesting twist to all of this, it appears that the state who prosecuted Hannah Gutierrez now wants her to testify against Alec Baldwin. How's that going to work? Well, the state wants to give her use immunity for her testimony. Take a look. Request this court grant use immunity to witness Hannah Gutierrez. And as grounds state follows, Ms. Gutierrez would testify that Mr. Baldwin was inattentive during firearms training session that she conducted with him. She would testify that Mr. Baldwin was a producer and had the freedom to do whatever he wanted, and the other producers had to reel him in all the time. Mr. Baldwin would become upset and have emotional fits. Mr. Baldwin was not supposed to be cocking the gun or pulling the trigger during the rehearsal when the gun went off. And that's a good outline, it appears, of the prosecution's case and theory against Alec Baldwin. So let's bring back in Jason Bowles because he's the attorney for Hannah Gutierrez. This isn't a plea deal, is it? This is just we're going to subpoena you and give you use of immunity and make you testify?
And that's the unfairness of it, just what you just said. So there was never a plea deal offered to Hannah throughout this case like there was to David Halls, the assistant director, for a misdemeanor. There was to Mr. Baldwin for a misdemeanor. There was a felony plea deal offered to Hannah for the same that she got convicted at trial. So now, after having been convicted at trial, sentenced to 18 months, the prosecution doesn't want to offer her anything, but they want to force her, compel her to testify against Baldwin. And they're predicting in their motion what she might say, although they've never talked to her. Because when they tried to interview her, Hannah invoked her Fifth Amendment privilege, as she is entitled to do. Because not only is she facing an appeal, Vinny, she's also been charged with a separate crime by the special prosecutor for bringing a gun into a bar in Santa Fe. So that's yet another charge that they are trying to pin on her. So again, the unfairness is really complete.
Well, can she be compelled to testify? I mean, is that going to happen at Alec Baldwin's trial? Because that testimony that they outlined there seems to be like a crucial part of their case.
Yeah, I think it would be. Now, she hasn't talked to Hannah, the special prosecutor, so she doesn't know what she's going to say. She will testify truthfully. Now, the judge, under the rules, if the judge grants this motion, can compel someone to testify over her Fifth Amendment privilege. However, that's in a normal case. This is a high-profile case, and I want to make the point at that hearing that whatever she says is going to be all over the news, all over the media, and jurors are going to hear it. She's got another charge pending for bringing a gun into a bar. She's got her appeal. This is not the normal case where you force somebody to testify, which the judge can, and then it still protects her. So I don't think it's going to protect Hannah. And we're going to assert her Fifth Amendment privilege.
Now, there's been another development relative to Alec Baldwin with his upcoming trial. This morning, he announced on his Instagram page that his family is launching a new reality show, The Baldwins. Let's take a look.
Hi, I'm Ilaria Baldwin.
And I'm Alec Baldwin.
And we have an announcement to make.
Good God, no.
No, definitely not. We're done having kids. Bye.
Sit down.
Oh. This is about our show.
We're inviting you into our home to experience the ups and downs, the good, the bad, the wild, and the crazy. Home is the place we love to be most. You say we are the Baldwins. We are the Baldwins.
No, we are the Baldwins. We all gotta say it.
Here we go.
1, 2, 3. We are the Baldwins.
Now, it's a lot of mouths to feed, so I understand why he continues to work and work and work. But what are your thoughts about Alec Baldwin continuing to work, continuing to speak, make statements, and now a reality show, all while homicide charges are pending against him?
Well, and I would not, if I were representing Mr. Baldwin, advise it. However, you know, he does have a family. He does have responsibilities. Again, I don't think any of these individuals that have been charged committed the crimes that the prosecutor has charged him with. You know, you don't want defendants to speak during the pendency of the proceedings. I think that's pretty standard. But I really can't comment on it. I don't represent Mr. Baldwin. I wish him the best and his family.
Let me ask you this, though. Locally, how do you think his celebrity plays inside the courtroom?
I think it's going to be a factor. I think, you know, people in Santa Fe obviously know who he is. I think that is going to be a factor in the trial that was different than Hannah's trial. And so, I mean, I think it could cut both ways. It's going to really be dependent on which jurors are selected. And as in any trial, I think you're going to have to be very careful in jury selection.
And one more final question. We have only about 15 seconds left. Do you think generally prosecutors are getting much more aggressive in going after accidental behavior and applying criminal liability to it?
I do, and that's a real danger, Vinny. I mean, you get medical malpractice errors occur all the time. Do we want to start prosecuting doctors and nurses in New Mexico? Do we want to run the whole film industry out of this state? Very big part of the state, just for mistakes, for accidents? I think it's a terrible precedent, very bad precedent.
Well, Jason Bowles, we appreciate you being very generous with your time tonight. Thank you so much.
Thank you. Appreciate it.
Thanks to both Jason Bowles and Vinnie Politan, but I have another update on this case a little bit later. But whether Hannah Gutierrez testifies against Alec Baldwin, we will have to wait and see, and I will bring that update when it goes down. All right, let's move onward. Okay, here's one for the Justice Serve file. An Ohio teen and her adult boyfriend pleading guilty, well, let's say no contest, in his mother's murder. 18-year-old KAITLYN COONES and 34-year-old Jonathan Jones were charged for the April 2023 death of Nicole Jones, Jonathan's mother. In court documents obtained by Court TV, prosecutors accused Coons of strangling Nicole and beating her with a rock on April 19, 2023. Following the murder, Coons and Jonathan cleaned the scene and disposed of Nicole's body in a dumpster. Afterwards, the couple fled to Mexico, where they were arrested in May. Nicole's body has never been found. Let's go to this video.
Turning now, though, back to Ohio, where 18-year-old KAITLYN COONES, along with her adult boyfriend, 34-year-old Jonathan Jones, were in court today to plead no contest to the murder of Jones's mother.
Now, prosecutors say Coons was upset with Jones's mother interfering in their relationship, so ordered him to kill her, but when he wouldn't do it, she committed the murder herself.
Now let's get you into that courtroom now to hear what the prosecutor had to say about the facts of the case.
Had this matter proceeded to trial with respect to count 1 on CR 232276 and CR 241092, the state of Ohio would have proven beyond a reasonable doubt that Jonathan Jones and KAITLYN COONES on or about April 19th, 2023 in Lucas County, Ohio, did purposely and with prior calculation and design cause the death of another, specifically Nicole Jones. With respect to count 8 in CR 232776 and count 3 in 24-1092, the state of Ohio would have proven beyond a reasonable doubt that defendants Jonathan Jones and KAITLYN COONES on or about April 19th, 2023 in Lucas County, Ohio, did knowingly and without legal authorization treat a human corpse in a way that would outrage community sensibilities. Specifically, Judge, the state of Ohio would have shown that on April 19th, 2023, Jonathan Jones and KAITLYN COONES worked together to plan, carry out, and cover up the murder of Nicole Jones, the biological mother of Jonathan Jones. That these events occurred at 7456 Timbers Edge Boulevard, located here in Lucas County, Ohio. The evidence would have shown that the defendant, Jonathan Jones, had been involved in an illegal sexual relationship with co-defendant KAITLYN COONES, starting when she was 16 years old. Mr. Jones was convicted in Wood County, Ohio, for charges relating to that relationship and for possessing images of a sexual nature involving KAITLYN COONES. While Mr. Jones was awaiting sentencing for those charges in Wood County, he was released on an electronic monitoring unit and was ordered to have no contact with KAITLYN COONES. The evidence shows that while the defendant was awaiting sentencing, KAITLYN COONES and Jonathan Jones nonetheless made plans for Ms. Coons to come to Toledo. She had fled the group home she had been residing in Akron, Ohio, and made her way to the defendant's home on Timbers Edge that he shared with his mother, Nicole Jones. Once there, the two planned to kill Nicole Jones because she was getting in the way of their relationship, and to some extent because the two desired to become an infamous couple. On April 19th, 2023, they waited until Nicole Jones was inside the kitchen of the home and had her back to them. They then beat her over the head with a rock and strangled her to death together. The Ohio Bureau of Criminal Investigation processed the home at Timber's Edge and found many droplets of blood consistent with a large bloodletting event in that kitchen. BCI determined that Nicole Jones was the primary contributor of DNA of that blood. Following the murder, the two went to several different home supply stores and bought cleaning supplies. The state would have shown the video surveillance depicting the two of them purchasing tarps, bleach, a mop, and garbage bags. In their recorded interviews, both defendants detailed wrapping the body of Nicole Jones in tarps and placing her into the trunk of her own vehicle. The two of them headed to dinner with the body of Nicole Jones still in the trunk of the vehicle. Afterward, they drove her body to a dumpster at a nearby apartment complex where Jonathan Jones previously lived and dumped her body into a dumpster. The two stole many of Nicole Jones's belongings, including a firearm, her jewelry, her checkbook and ID, and together they removed all the money from her bank account. The electronic monitoring unit that Mr. Jones was wearing at the time of the murder would have showed his movements throughout Toledo during this period of time, corroborating the facts as stated above. Afterward, the defendant cut off his monitor and fled with KAITLYN COONES in his mother's vehicle. They proceeded out west through Arizona, where KAITLYN COONES is alleged to have committed additional crimes. Eventually, the two made their way to the country of Mexico. While on the run, the defendant KAITLYN COONES was posting on Facebook about having murdered people and texted several others telling them what she had done. One of these individuals that saw her post contacted the Akron police where KAITLYN COONES was to be residing. Akron police then notified the Sylvania Township Police Department of what had been reported, and in response, the Sylvania Township Police Department responded to the victim's home to check her safety. She was obviously not there, and during the execution of a subsequent search warrant, officers discovered the blood and missing items. Warrants were then issued for the arrests of Jonathan Jones and KAITLYN COONES. Meanwhile, while the defendants were in Mexico, they were stopped and arrested because Mr. Jones was in possession of marijuana and KAITLYN COONES was determined to be a minor traveling without a legal custodian. Eventually, they made their way back here, Judge, to face these charges. The defendant, Jonathan Jones, was interviewed by several agents and gave a lengthy statement. He claimed that on April 19th, 2023, while they were in the Timbers Ridge home, that KAITLYN COONES gave him 5 hours to kill his mother. And then when that time elapsed, she did it on her own while he stepped out for a cigarette. However, his statement contained several inconsistencies and the improbable self-serving statement that KAITLYN COONES, acted alone in the killing. For instance, Jonathan Jones further admitted in this interview that after they murdered Nicole Jones, he was covered in blood and that the two of them showered together. He then indicated that while the two of them had fled, he wasn't thrilled with the situation, but that he was happy that he and KAITLYN could now be together, and noted that his mother always interfered with their relationships. The defendant, KAITLYN COONES, in her first interview, did claim to have killed the victim all on her own as well, a claim the state would have proven was false and done in part during as part of a plan the two of them had contrived together, whereby Mr. Jones was asking KAITLYN to take full responsibility for the murder to receive a lesser sentence since she was a juvenile, in the hopes that he would then also receive a lesser sentence. However, in her second interview, almost a year later, the defendant, KAITLYN COONES, provided a different statement. This time, she placed nearly all blame for the murder on the defendant, Jonathan Jones. In this statement, she depicted Jonathan Jones as coming in through his bedroom window with a large rock. He then demonstrated for her how he would strike his mother over the head and stated, "I'm going to do it now." She further claimed that she heard Nicole Jones scream out and gurgle blood, and that she waited for it to be over. That when she came out of the bedroom, she saw Jonathan Jones with his hands around the victim's neck, asking for her help, to which she complied, of the belief that finishing Nicole Jones's life or ending it would bring them closer together as a couple. She further stated while she did give Jonathan Jones a timeline within which he must kill his mother, she never thought he would carry it out. Both defendants gave statements at one point where they each removed themselves from the crimes at the increment of time of critical importance, which would be the ending of Nicole Jones's life, and that they did this for a reason, because they committed out these acts together. The evidence also would have included jail calls and jail letters between the defendants, wherein they are professing their love for one another, and one in which Jonathan Jones repeatedly directs KAITLYN COONES to continue admitting to the murder so that the state would not think that he was the mastermind behind this crime, possibly giving him a lesser sentence. While the body of Nicole Jones was not recovered in this case, the state would have shown the death of Nicole Jones through circumstantial evidence, including no cell phone activity, money transactions, communications, or sightings after April 19th, 2023, in addition to the fact that both defendants did in fact admit that she was murdered and that her body was disposed of in a dumpster. To the extent that the defense would have attempted to argue that KAITLYN COONES was afraid of Jonathan Jones, we would have shown that she continues to seek him out, profess her love to him, and that while fleeing never attempted to notify authorities, call for help. Further, we would have shown a video taken from Ms. Coons' phone that depicts her smiling and laughing in the stolen vehicle while Jonathan is driving, following their flight after the murder. And the video pans down to her purse where it shows, she is in possession of a firearm. We would have argued and proved that she was not in any fear and that she had the means, specifically a firearm, to disengage herself from the defendant. The evidence would have been clear, Your Honor, and proven beyond a reasonable doubt that both defendants acted in concert to plan, murder, and dispose the body of Nicole Jones. They committed these offenses together every step of the way. Based on that statement of facts, we are asking the court to find both defendants guilty of aggravated murder and abuse of a corpse. Thank you.
Horrific.
I don't know what else to say regarding that case. I mean, I've heard of forbidden love, but that is just so over the top, so sickening. In order for a 17-year-old girl to want to be, not actually be, but want to be together with a 33-year-old grown man, she had to, one, coerce him into killing his mother. And then on top of it, when he doesn't get the job done, she goes by the old adage, if you want something done right, you got to do it yourself. And then actually does it. What is going on here? What is going on here? I know I'm having my say right now, and I know when I go back to this clip, Judge Ashley Wilcott and Michael Ayala, shout out to them at Court TV, they're gonna have their say about this. But still, what could go through someone's mind to even remotely think about killing someone's mother just for, dare I call it, forbidden romance? Let me go back to Judge Ashley and Mike for their commentary real quick.
Big facts and plenty of evidence for those facts. So why was there a plea? We'll be talking about that a little later.
It's hard for me to understand that they were given a plea to plead no contest, but also they get opportunity for parole after 25 years. No guarantee they'll get it, but that still sounds like a sweet deal.
Yeah, it does to me too. Horrific crimes. Coming up next, though, we're going to hear from the victim's brother as he describes the difficulty of losing his sister at the hands of his own nephew. Stay with us. We'll be right back.
Tonight on Closing Arguments, new details revealed.
Welcome back to Court TV Live. Michael Ayala here with Judge Ashley Wilcott. Now, we're in Ohio now, where 18-year-old KAITLYN COONES, along with her adult boyfriend, 34-year-old Jonathan Jones, were in court today to plead no contest to the murder of Jones's mother, Nicole.
And now we are hearing the victim impact statement of Robert Jones. This is the brother of Nicole, who spoke of the difficulty of losing his sister to her son, and he also criticized the community's response to her disappearance. Let's go back into court.
My name is Robert Jones, and I'm here today to speak on behalf of our beloved sister and daughter, Nicole Jones. No words can fully capture the depth of our grief, the extent of our pain, or the magnitude of our loss. Nicole Jones was a beacon of light in our lives. She was a devoted mother, a cherished daughter, and a loving sister. Her kindness, her laughter, and her unwavering support reflect the foundations upon which our family stood. Her murder has shattered our world, leaving a void that can never be filled. The agony of losing Nikki is compounded by the unimaginable betrayal we feel, knowing that her own son and his girlfriend committed this heinous act. The trust we once placed in Jonathan Jones has been irrevocably broken. And the sorrow we feel is intensified by the confusion and disbelief that someone so close to her could be capable of such brutality. Nikki was always there for Jonathan without question. The fact that he failed her in this moment is incomprehensible to our family. The physical absence of Nikki is a constant, searing wound. The fact that her body was never recovered adds a layer of torment that words cannot describe. We are denied the closure that comes with laying a loved one to rest, and we are haunted by unanswered questions and horrific imaginings of her final moments. This perpetual state of limbo exacerbates our suffering and hinders our ability to heal. The emotional toll on our family has been devastating. We struggle daily with feelings of tremendous pain, anger, and profound sorrow. Each milestone, holiday, and family gathering is a stark reminder of her absence. The laughter that once filled our family gatherings has been replaced by silence and tears. The comfort of her presence is now a cherished memory that we cling to in our darkest hours. This horrible tragedy has also weakened our faith and belief in our local community. Nothing was done to attempt to recover our family member, and decisions were made without consulting us or even reaching out to us to express any sorrow or remorse for the decisions that were made. At the time our family needed the basic services of the community the most, the system was unable to perform its most basic duties. The inaction of some has cast a cloud over our sense of safety and belonging. The place we grew up and raised our families doesn't feel like home. Despite this, we will forever work to honor Nikki. Our family's future is now overshadowed by this tragedy. We find ourselves grappling with a profound sense of loss and a relentless ache in our hearts. These defendants' actions have irrevocably altered the course of our lives, robbing us of the joy and presence that Nikki brought to us. We stand before you today seeking justice for Nicole Jones. We implore you to consider the immense pain and suffering inflicted upon our family and to hold the defendants accountable for their actions. While no sentence can bring her back or erase our anguish, we hope that it will provide some measure of justice and deterrence, preventing other families from enduring the nightmare that we now live. Your Honor, we ask that you remember Nicole Jones not as a victim, but as a vibrant, loving individual whose life was tragically cut short. We ask that you honor her memory by delivering a sentence that reflects the seriousness of the crime and the depth of our loss. Thank you for allowing us to share our story and for considering our plea for justice. Thank you, Your Honor.
All right, just an emotional moment for him, for his family, the entire thing, just an ordeal. Let's bring back in our guest, criminal defense attorney John Mobley. John, I want to get your thoughts on this deal in this case. Both the judge and I feel like we're struggling understanding why the state would give what we consider to be a sweetheart deal.
You know, Michael, I got to call it like I see it. I was thinking the exact same thing when I saw it was allowed to be a no contest plea. You have an extremely brutal, graphic murder. It just doesn't make any sense.
Yeah, it doesn't. Thank you so much, John, for joining us this hour.
Jonathan Jones and KAITLYN COONES are extremely blessed to get this kind of a deal. To not to go through a trial, be put on the witness stand, and testify as to what they did, how they did it, and then trying to flee from the consequences. But I can tell you straight on, they may have gotten lucky to get this sweetheart deal here, but you can bet in eternity there is no plea deal. There is no plea of no contest. And my better half, Lady Outlaw, signaling something to me. What's up, sweetheart? Okay. Anyway, I really can't say for certain that justice is served in this case, because like we can't all agree that whatever KAITLYN COONES and Jonathan Jones will be sentenced to, nothing will bring back Jonathan's mother, Nicole. That's for sure. Now, the reason I had set this up for Saturday night, and I did say this would be a summer sizzler, I am going to show you and give you a little bit of Court TV's analysts on this body cam footage with both Stephan Stearns and Jennifer Soto regarding the missing persons case and the eventual murder of Madeline Sophia Soto. And believe me, guys, there's a lot to unpack in this one. So I'm going to go ahead once again, give you the trigger warning. Okay. And I'm going to give you the copyright disclaimer. All right. Now that we got all bases covered, all I's dotted, all T's crossed, let's go back to Court TV and this body cam footage and the analyzation of it.
February 25th was Madeline Soto's 13th birthday party, celebrating a new phase in her life, becoming a teenager. There was a party. Her mom, Jen Soto, could not make it, but her mother's live-in boyfriend, Stephan Stearns, was there, a man who had been in Madeline's life for more than 5 years. In fact, Jen referred to him as Madeline's stepfather, even though they were not married. The next day, Jen and Stephan say Stephan gave Madeline a ride to school. They also say Madeline was embarrassed and did not want to get dropped off in front of the school. So she was dropped off near a church parking lot less than half a mile away. That's the last time they say anyone had contact with her. Investigators say the evidence paints a much different picture. They claim they have evidence of Stearns dumping Madeline's laptop and backpack in a dumpster and have images of Madeline dead inside of Stearns' car. Madeline never made it to school that day and was found 4 days later in some brush on the side of the road in St. Cloud, miles from their home in Kissimmee. Stearns was arrested after images of Madeline being sexually assaulted were allegedly found on his phone. And since then, he's also been charged with her murder. Jen Soto has not been charged with anything or named as a suspect. Now, for the first time, we are seeing body camera video from the officers who first responded to the call for a missing girl. What does this video show? What does it reveal? We'll take a look along with our body language expert as we continue to investigate the tragic life and death of Madeline Soto. I'm Benny Politan. Thank you for joining us tonight here on Closing Arguments. We have a big hour ahead here, and this is an important hour as we continue to investigate what happened to Madeline Soto. First thing you have to understand is that she was missing all day. She never made it to school. Never made it to school. The big question is when exactly was she murdered? That question has not been answered yet, and we know a lot, but this story began for investigators as a missing child story, a missing child investigation. And it was the Orange County Sheriff's offices, those deputies, who responded to that call. And when they responded, their body cameras were on. And that's what we're going to see tonight. That's what we're going to take a look at tonight, is some of the video from those officers who responded to that call. And you have to understand, from their perspective, it's a missing 13-year-old, a teenager. And what exactly were the circumstances behind this? And the focus initially has to be, okay, what do we know? What can we find out? Where was she last seen? Where should we be looking? And all of that transpired in some of these videos, but the question is, where are you getting this information from? Well, you're getting it really from two sources as they respond. One of those sources is Stephan Stearns, the one who's now been charged with the murder, the one who's been charged for all those images that were allegedly found on his phone. And this is his opportunity to tell his first story to police, to law enforcement. And he tells it to the deputies. And it's really, when you look at him, he's got this crazy thing on his head. The arms are crossed the whole time. What exactly is going on with Stephan Stearns as officers respond? Because based upon where we are now in this case, is a much different place than we were when those first Orange County deputies responded and spoke to Stephan Stearns. Fascinating to look at that. Also, Jen Soto is there, and she's actually speaking more than Stephan Stearns. What is she saying? What is her body language saying? That is something we're going to take a look at tonight. But first, let's play for you one of the videos. And this is the video of the first responding officer making the first in-person contact with Jen Soto and Stephan Stearns. Let's take a look.
Of course. Do they speak English?
Yes, this is Mom.
This is Mom? Okay. Hi there.
Hey there.
Hey there. What's going on?
So, my daughter was dropped off close to school this morning, but never made it. I went to pick her up from school.
I'm sorry, one second.
Yeah.
Go ahead, sir.
Are we looking for another kid, or we have a kid?
Looking for another one.
Alright, so people are still on the scene. Let's put that out. Any hospital location. How long?
13.
I'm trying to get there right now.
Absolutely.
Okay. So she was supposed to be dropped off at school, didn't make it to school.
Didn't make it to school. I went to pick her up from school today,
Okay.
and she never came out. They announced it over the speaker, and I'm just like, maybe she walked here, because sometimes she'll walk here to this office. I came here, nothing. I went back to the school, they were closed. I got a notice, an email from the school saying she was absent, but I also messaged her teacher, and he looked at her entire attendance today and saw that she was completely not at school today either.
Okay.
So she never made it.
Okay. What's her name?
Madeline. M-A-D-E-L-I-N-E.
M-A-D-E-L-I-N-E. Last name?
Soto. S-O-T-O.
S-O-T-O?
Yeah.
Date of birth?
February 22nd, 2011.
February 27, 2000?
22nd.
Oh, sorry. 22nd,
2011.
2011.
Just her 13th birthday.
13.
1418, what's the name of the single aid?
Madeline Soto, age 13. I'm trying to get a clothing description now. What was she last seen wearing?
26 County Killer 405. People hit my call 931. It's the same call.
Green hoodie.
Green hoodie.
White Crocs.
White Crocs.
Either blue or black pants.
I think black shorts.
Black shorts?
Yeah.
Black shorts? Okay. Black shorts. Alright. Do you know if she has like friends in the area?
She does, but she doesn't know where they live.
She doesn't know where they live. Okay.
I asked all of them.
Okay. Is this like, does she like have any places that you guys know that she'll usually be at? Any friend's house? Any places that like she likes to hang out?
Not typically, no.
No.
Not typically?
No.
Okay. Just give me 1 second. Let me see if I get some.
Thank you.
No problem. And what school she goes to?
Hunters Creek Middle School.
Hunters Creek Middle? Alright, cool. 125. Do you have a picture of her? Can you airdrop it to me?
Yeah, I know. Let me see which picture. I don't know which picture.
Okay, recently, probably from a birthday party, right?
Yeah, but I wasn't there, so I have to look at. What's up? Me, I guess. Where's your
Go ahead. That's what I'm about to grab right now. Yeah. Alright, cool, thank you.
Is this a good enough picture, or do you need a whole body picture? Okay. Put my eardrop, I don't have to.
I got you. Okay, where's the photo? Right there.
It's on WhatsApp.
That's fine.
I saved it to my photos, so you could go.
You saved it to your photos?
Yeah, we could just
Perfect.
go straight to the photos.
Okay, perfect. Give me a second. Yeah, I'm gonna send it out right now to my other guys.
Thank you very much.
No problem.
All right, so I'm watching this. Two things strike me right away. The first being the general kind of tone and atmosphere where Jen Soto is, Stephan Stearns, and the rest of their family. There's an eerie calmness in there. Now, I don't know if things were hectic before or things get hectic after. I'm wondering when and maybe a lot of searching was done before this moment, because this is like, you know, 8 o'clock at night. I don't know. I'm trying to understand that part of it, because I don't know what happened before this, and I don't know if there's something that happens after this. But in this moment, everyone's kind of sitting around very calm with a just turned 13-year-old girl missing. That really strikes me here. The other thing is Stephan Stearns. It's tough to look at him. Let me bring in my guests. Joining me in Orlando, Florida tonight, WFTV investigative reporter Shannon Butler. Also with us, retired police commander, host of the Profiling Evil podcast, author of the book Deceived, and all proceeds from the book this Deceived are going to Child Victims Center, which is being built. So that's important stuff. Mike King is with us, but we just lost him momentarily. Let's go straight to Shannon Butler, WFTV investigative reporter. Shannon, your first initial reaction to this first video that we just watched.
Well, my first reaction was the same as yours. I couldn't believe how calm Jen Soto was. We're both parents, Vinny. We both have children. And if my daughter was missing, I don't know that that would be my reaction to that. But when you look at Stephan Stearns, he seems almost uninterested to be there. Like, here we are, it's late, we're sitting here, we're talking to police. His behavior is so strange to me. He doesn't seem alarmed by any of this. It's easy to say that now because we know so much more than we did the day that this video was taken, but their behavior, I think, raises a lot of questions for a lot of people.
Do we know, Shannon, if they had like searched the area themselves, like earlier in the day, trying to figure out where Madeline could be? Because they know that she didn't go to school. So at this point, it's 12 hours it's about 12 hours that she's missing.
Yeah, there were a lot of questions about what that amount of time. Now, she called police as soon as, that the little girl didn't make it to school. But if you remember, Stephan Stearns was really clear that he didn't do any of the searching. Remember, he said, I don't know what was doing, but he didn't search at all. At this point, our understanding, there was no, searching to see if she was nearby. I think they were trying to gather, what happened. But no, they were not out there, going through the bushes and things like that we know of. We have not been told of any of that. And usually something like that would be hard to even for us not to hear. Somebody and said, hey, there's a huge search for a little girl this afternoon. We don't see her. But Stephan Stearns was very clear. He didn't search for her.
And he's the one who knows, according to his story, right? Exactly where he dropped her off, where he was. How on earth, if that child didn't make it to school, you're not there looking and searching and calling police and calling as many of your friends, if you have any friends, co-workers, everyone together. Let's find, because I know at some point there was a search, right? At some point there's a search?
Well, it wasn't like a community search. You know, we've seen with other cases how you get the community out and they start doing searches. Police do what's called a grid search in those kinds of areas. But this didn't happen in this case, which was really interesting. There was not huge search parties. So it was very clear from the beginning that those investigators already knew that there was no reason to look for her at least alive in that general vicinity. Remember, they had video very early in this case, and they had already believed that Madeline Soto was dead. At that point, immediately it turned into, we hope that someone gives us a tip so we can find where Madeline Soto might be. And in the end, that's exactly what happened. But this was not a case where we had huge search parties.
All right, I think we have Mike King with us now. Mike, great to see you. Thanks so much for joining us. We're looking at this. We looked at this first video, the initial contact in person that's made by deputies. Interested in your initial reaction here, right? This is at this point, purportedly a missing child case. Your thoughts about Jen Soto, Steph Stearns, in this initial contact that is made?
You know, Vinny, I felt like I was watching a rerun of the missing boys in California and the mom and the dad, or at least the foster parents as they got up. The thing that really jumped out at me was that we talk about crime scene staging, but this is more story staging, because she stepped right up with a story that seemed like she'd rehearsed a little bit. It may have even been in cue with what she was directed to say. And I think it's going to be interesting to see if there's some coercive relationship going on between the two as this thing unfolds. But he stands back kind of watching, and boy, you can tell how unhappy he is about being there. But she starts right off with a story that she's already prepared. We dropped her off at school. It was a little bit early. We watched her walk away. And all the other staging that we heard Stern going through with, hey, I'm a good guy. I took her to McDonald's. She didn't want it. I said goodbye. I love you. Oh, by the way, she said, I love you too, as she gets out. All of that verbal staging really jumped out at me, Vinny.
All right, our guests are staying with us. We've got more videos to look at. Plus, coming up next hour. Karen Reed is accused of murdering her Boston police officer boyfriend John O'Keefe with her black Lexus. Fusion says proved murder, and the pieces of evidence that
cold for over a decade.
Okay, how about, does she have a phone number or phone?
She does, but she left it at home today. I have it.
You have it.
And I've already gone through her messages.
Okay, how about, does she have like Apple Watch?
Like, she's got a device. The only device she's got on her right now is her school laptop.
Her school laptop, is that trackable?
I don't think so.
You don't think so?
Now, there is one thing I gotta agree with one of the guests in this segment. How can anybody, much less a mother, be so calm that their daughter or their child is missing, and a parent be as calm as that? Not me. I couldn't do it. If my child is missing, I'm going to be hysterical. I would want to know what law enforcement is doing. When is it happening? How it's happening? And then the bottom line is, find my child. There's no way I could be this calm. But as
a lot of moving parts in this video, and this is, again, the first contact in person. Orange County deputies responding to the call for a missing child. Let's take a look now. We've got a second video to look at from a second deputy. Again, here's Jen Soto, Stephan Stearns telling the stories.
piece church. Like in front of these communities out here.
By any chance, does she have a phone number or phone?
She does, but she left it at home today. I have it.
You have it.
And I've already gone through her messages.
Okay. How about, does she have like Apple Watch?
She's got a device. The only device she's got on her right now is her school laptop.
Her school laptop? Is that trackable?
I don't think so.
You don't think so?
It should be. It should be.
If the Wi-Fi is turned on, it'll try to connect to any Wi-Fi. So if I like circle here,
it connects to any USB position.
Well, does she know have a history of running away or anything?
Never.
She was hanging out last time kind of?
Possibly, I don't know. She got dropped off. She was like, so she's in Belarus by his car. So she didn't want to be dropped off at school. She wanted to be dropped off like half a block away so she can walk.
It's an image thing. She's in the face.
But he dropped her off half a block away and drove away.
Okay. Did she ever go to school though?
No, we called school.
She was walking in that direction. She was rifling through her backpack, just looking for something. I thought maybe she was just looking for headphones before she got her walking on.
Yeah.
But she was just kind of, shambling over in that direction. It looked the same as any other morning. Okay.
What was the last thing you asked?
If she ever went to school, I guess.
So I got confirmation from the school that she never made it. They sent me an email saying she didn't make it. But I also spoke to her, or emailed one of her teachers directly, and he looked at all her attendance for all her periods and told me she didn't make it at all today.
Okay.
Say it again? No, she's supposed to have a book bag. She was supposed to go to school, but didn't go to school today. Dia said negative on that hit at the park. So.
Say 21 to a vehicle. Pursuing local, reference say 21 to a vehicle.
I think black shorts.
An unknown male, gray hoodie, black pants, black He-Man, black gloves. No further information, 1064, 1946.
And when was the last time you seen her? Do you know around what time?
Around 8:30, 8:40 when we dropped her off. How tall is she?
5'1".
Yeah. Weight?
110 pounds.
110, 120. Hair color?
Blonde.
Blonde, like a dirty blonde. Like a dirty blonde?
Yeah.
Okay. Eye color?
Blue.
Does she have any markings on her, like any scars or anything like that?
There's a distinctive beauty mark on her face.
On her face?
On the face, like below the nose or near the nose? Yeah, like right in that area there. It's very distinctive. You'd know it if you saw it. Big.
Any other scars or anything like that we should know?
Scars?
No.
Tattoos?
Tattoos? No.
You'd be surprised. Did you put out the description?
I put the top part out. I didn't get the rest of that stuff yet, so I can put it out.
County 342. Updated 14. 48. White female.
Can I just see that phone?
Black shorts. White contact glass. Possibly 5'1" height. Blonde, dirty blonde hair. Blue eyes. Has a beauty mark under the nose.
I'm getting a random 407 number. Okay. Hello? Yes? Hi, Principal. I'm okay. How are you?
That's right.
No, currently police officers here right now.
Get started in the
Yeah, I'm trying to see if I can find her
paperwork. Does she have any social media or anything like that?
She has Instagram.
Right here.
OBT, TEPHAN, 838.
Just family,
Thank you
cousins.
so much. I definitely appreciate it.
Right here.
That's her profile?
Yeah.
Little figure?
She also has a YouTube page.
Okay. Any Snapchat or?
No. She plays games.
No, that's
Still with us, WFTV investigative reporter Shannon Butler and retired police commander Mike King. Mike, the laughter, could we chalk? Is it nervous laughter, or is this like? Did it make you feel uncomfortable?
Yeah, it made me feel uncomfortable, Vinny, but you're absolutely right. We have to be able to understand what's normal for them. But I'll tell you something that really stood out to me that hasn't jumped out before, but it really bugs me, Vinny, and that is that as soon as she picks up that phone and says, yes, principal, he doesn't turn to look and say, has somebody found her? I mean, he's got this resolute look on his face, and it's like whatever's going on isn't going to change a thing.
Shannon, I know you've also taken a look at a new discovery list, some new documents. What can you tell us about that?
Well, the discovery list is basically a list of things that we know now what investigators used in their investigation or anything that they found. And there is dozens and dozens of items. But one of the things that we thought was interesting when we went through some of this over the last couple of days is that those Orange County detectives did use trackers on the vehicles of Jen Soto and Stephan Stearns in those days while they were still looking for Madeline Soto. We did know that there was some video had picked up along that route between their home and where Madeline's body was found. We now know there were, the 7-Eleven, we knew that they had video there. And then I think I've told you guys before, there was video at kind of an industrial type park on the way. Our understanding is that's video where they see him move one location to another from the front seat into the trunk. So we know that in this case, they do have more video evidence that we saw from the apartment complex with the backpack and things like that. It does appear that investigators had quite a bit of evidence very early on in this investigation. It was, of course, that tip from that passerby that helped them locate Madeline's body, but they were pretty well ahead of the game very early on in this investigation.
And Mike King, something else we're looking at, if you look at Stephan Stearns right here on his arm, he's got a Fitbit. That could be a source of information as well.
Yeah, absolutely, Vinny. And the fact that they really have a pretty good cellular system set up through that part of Florida. They're not only are pretty good cell towers and they're in good proximity with a pretty good direction, but they've got microwave and they've got small cell installations. So I think when they're starting to look at the forensics in this particular case, including the bird dog information that they put on the vehicles to track him, I think they're going to really put together a nice breadcrumb trail.
Shannon, what did you think of the dynamic? I know you guys interviewed them together, and everyone looked at that and was, quite striking. How about in this video? Do you see any sort of different dynamic between the two, or is it consistent with when WFTV, you guys did the interview with Madeline Soto and Stephan Stearns?
Yeah, it appears to be pretty... It looks the same. It's easy for me to say that now because of how much we know about that couple now. But he was very stoic, kind of like he is here. And I don't know, he almost seems kind of put out by what's going on here. Even in that investigation or that interview that we did with him, he was just so matter of fact, like I dropped her off. She was rifling through her backpack, things like that, which we know not to be true because the backpack was found in the dumpster. But her behavior also the same. She's, kind of quiet and reserved, even in our interview and even here. But it felt to me then, and it feels to me now, that I'm not sure she's sure about the story of which she gave. For whatever reason that may be, she doesn't seem as solid in that information. I mean, she doesn't even know what color shorts Madeline Soto's wearing. They were blue, not black. So that's pretty consistent with what we saw when we talked to them. His behavior, his arms crossed and things like that was just how he was when we saw him.
Mike King, understanding the dynamic of the relationship, I think is going to be crucial for the trial or trials of Stephan Stearns. What role does Jen Soto play? Cooperating witness? Is she a potential co-conspirator? Does she face any charges for any of her conduct before, during, or after the fact? To me, that is still the big unknown question in all of this.
Yeah, I agree, Vinny, and I think that their law enforcement's in a perfect position to work with her, and it doesn't seem like she's lawyered up or been resistant to that. And with him now sitting in jail, she's not facing any of that pressure that she might if they were still in the same house together. So I think it's really incumbent on law enforcement as they continue to massage this thing and try to get more information to really see if they can separate. There may be immunity that's offered, who knows? There may be a little bit of pressure put on her for some things like just the responsibility to protect that child, and having her sleep with this guy that she's living with isn't protecting that child. And then I guess the final thing that I would say is it's too bad in hindsight that law enforcement didn't split them up right then, because those two were just kind of acting hinky. But I love the fact that we have an expert who has dealt with them and interviewed them for the media that can say, well, the behavior's kind of consistent.
Yeah, absolutely. Mike King, Shannon Butler, thank you so much for joining us on this big, big night. When we come back, we'll take a look at some of the clips with our body language expert. Don't go anywhere.
Yeah, this is the part I'm waiting on. Having a body language expert analyze the body language of both Stephan Stearns and Jen Soto for because the way they acted and reacted as far as the reporting of Madeline missing, it just didn't make any kind of sense. So I want to see what the body language expert has to say in this. So hang tight, guys. We're about to go on a bit of a ride.
Life.com.
This is Mom.
This is Mom? Okay.
There.
Hi there.
Hey there.
Hey there. What's going on?
So my daughter was dropped off close to school this morning, but never made it. I went to pick her up from school.
Sorry, one second.
Yeah.
Go ahead, sir.
Are we looking for another kid, or we have a kid?
Looking for another one.
Alright, so people are still on the scene. Let's put that out. Any possible location. How long?
I'm trying to get there right now. Okay. So she was supposed to be dropped off at school, didn't make it to school.
Didn't make it to school. I went to pick her up from school today, and she never came out. They announced it over the speaker, and I'm just like, maybe she walked here, because sometimes she'll walk here to this office. I came here, nothing. I went back to the school, they were closed. I got an email from the school saying she was absent, but I also messaged her teacher, and he looked at her entire attendance today and saw that she was completely not at school today either. So she never made it.
I want to take a deeper dive now into this new body cam video of Jen Soto and Stephan Stearns when they first report Madeline missing. Bringing a special guest, body language and statement analyst expert Bruce Jacobs. Bruce, thanks so much for joining us tonight. Great to have you here.
Hey, thanks for having me on.
All right, let's do this. I'm going to put on a clip and let's watch it together. Then afterwards, you tell me what you're picking up from Stephan Stearns and Jen Soto. Let's take a look at the first one where they give some basic info.
What's her name?
Madeline. M-A-D-E-L-I-N-E.
M-A-D-E-L-I-N-E. Last name?
Soto. S-O-T-O.
S-O-T-O?
Yeah.
Date of birth?
February 22nd, 2011.
February 27th, 2000?
22nd.
Oh, sorry, 22nd.
2011.
2011.
Just her 13th birthday.
13th.
Charlie 45. What's the name of the single aid?
Madeline Soto, age 13. I'm trying to get the clothing description now. What was she last seen wearing?
26 County Charlie 45. People hit my call 931. It's the same call.
Green hoodie.
Green hoodie.
White Crocs.
White Crocs.
Either blue or black pants.
I think black shorts.
Black shorts?
Yeah.
Black shorts?
All right, Bruce, what are you picking up here? Is they're just giving some of the basic information?
Yeah. So let's go back to when they first came in, the officer first came in. What's the first thing that Stephan did? He takes a big swig of water. Okay, that's a limbic brain response. Most of the ancient lie detector tests are based on your saliva, your dry mouth. So then he reaches back and he puts the water bottle behind him, and he comes up and he starts to put his hands in his pockets. But then he changes his mind and he crosses his arms. We call that torso blocking. Okay, so when people are feeling threatened, they'll torso block. Your limbic brain, which is your fight, flight, or freeze brain, has a vested interest in protecting these organs. So as soon as he does that, now it doesn't always mean it's a close stance. It depends on the circumstances and the context of when it's happening. But then he uncrosses his hand and he touches his forehead. Again, it's a limbic brain response. It's a pacifier. So he wants to run or fight, but he can't. So he's got to calm himself down. So then mom answers the phone and hands it to him. So he takes his hand and he takes his thumb and puts his thumb in his pocket. So most people, when they put their hands in their pocket, they either put the whole hand in, right, or they'll leave the thumb out. So hiding your thumbs is a great sign of lack of confidence. So he talks on the phone a little bit, hands the phone back to her, and he immediately goes back into the closed stance and again touches his head, touches his forehead. So these are limbic brain responses, that it's a fight, flight, or freeze response. So those are great clues. I have to agree with the other people in the beginning that there's almost an eerie calm here. So I look at mom's bobbing back and forth. She's got the exaggerated sway back and forth, but she's pretty much repeating what she's been told. So I didn't see too much on her. There was some emotion on her face. She had some forehead, some tension in the forehead as she was talking also.
Okay, I've got a second clip. In this one, they get into more of the details of the actual story. Let's watch that one.
She got dropped off. She was like, so she couldn't barely just find his car. So she didn't want to be dropped off at school. She wanted to be dropped off like half a block away so she can walk.
It's an image thing. She's in the face.
But he dropped her off half a block away and drove away.
Did she ever go to school though?
No, we called school.
She was walking in that direction. She was rifling through her backpack, just looking for something. I thought maybe she was just looking for headphones before she got her walking on.
Yeah.
But she was just kind of, shambling over in that direction. It looked the same as any other morning.
Bruce, are you picking up anything in just the dynamic between the two?
Yeah, so she's explaining to the officer what's going on, and he steps over her from behind. Now, he doesn't have his hands crossed here because she's in front of him. It's like standing in front of a podium, right? She's blocking for him. So he adds that in there, like she's going through a phase. So he's kind of minimizing it. He doesn't use the word just to minimize it, but he goes, she's going through a phase. And he talks about dropping her off about a half a mile away. Well, that's a long ways, but okay, maybe he did. Obviously he didn't know. So he says, and then he starts talking about what happened. And one time he says, he's talking about how she was rifling through her backpack and then she stammers away. I think that's the word he used. And then he goes, so he uses the word or the phrase for the very first time in all the body cam clips. So has two meanings, unless it's his baseline, has two meanings. One of them is he's trying to monopolize the conversation, and the other one he doesn't know a whole lot about it. So he's trying to convince us, that she was stumbling through her backpack, and then he adds something at the end, this unnecessary language. It looked the same as any other time. So what he's saying is that every other time she stumbles through her backpack, and he kind of acts like she was walking, imitates her. So I found that very odd, that he was trying to convince us because he uses the phrase, and he says, just like every other time. So every other time she is going through her backpack looking for her headphones.
Yeah.
Lots of deception there.
Final one, and this time they talk about the last time they saw her, but there's also a moment where I think people laugh a little bit. Let's take a look at that.
And when was the last time you seen her? Do you know around what time?
Around 8:30, 8:40 when we dropped her off. How tall is she?
5'1".
Yeah. Weight?
110 pounds.
About 110, 112. Hair color?
Blonde.
Blonde, like a dirty blonde. Like a dirty blonde?
Yeah.
Okay. Eye color?
Blue.
Does she have any markings on her, like any scars or anything like that?
There's a distinctive beauty mark on her face here.
On her face?
On the face, like below the nose, or near the nose? Yeah, like right in that area there. It's very distinctive. You'd know it if you saw it. Big.
Any other scars or anything like that? Which you know?
Scars?
No.
Tattoos?
No.
You'd be surprised.
Okay, let's begin with the laughter in this moment. Was it nervous laughter? What are you getting from that?
So I thought that was very odd. I wouldn't be laughing if my daughter was missing. One of the things that one of the clues of communication, channels of communication, is the voice. So it's the pitch, the tone, the volume, the inflection, and the flow. And sometimes his volume goes way down. So when he's describing certain things about her, his volume comes up to his level. But then when he's talking about, especially when he says dirty blonde, his mouth opens up. It's the only time it happened in the whole body cam. He goes dirty blonde and his mouth opens up. I don't know why that happened, but we look for consistencies and inconsistencies. So then about the tattoos, yeah, everybody started laughing. I thought that was very odd. I do agree that when the principal called, there was no response to him. I think about you as being a parent. You know, if a phone call comes and your wife starts talking about it, you're like, did they find her? Did they find her? There was no reaction from him at all.
Zippo, much like Scott Peterson. Bruce Jacobs, great to have you on the program tonight. We're out of time, but we will do it again. Trust me, we will do it again. Thanks so much, Bruce.
And that bit shows me that that Stephan Stearns was trying to control the narrative, not without saying a word, and Jen Soto could have been compliant just because. Which still brings me back to that same question that I was asked earlier. What part will Jen Soto plays when Stephan Stearns goes to trial? Will she be a concerned parent, a witness, or will she be a co-conspirator and end up being a defendant? We'll just have to wait and see what becomes of this case as this mystery unravels. All right. Moving onward on this sizzling Saturday night, a trial that's already in progress. The Taken Teen Murder Trial. Georgia versus Miles Bryant. Now we got a former police officer accused of kidnapping and murdering a teenager. 23-year-old Miles Bryant charged with murder, criminal attempt to commit rape, kidnapping, and concealing the death of another in the death of 16-year-old Susana Morales. He is also facing charges of filing a false report over allegations he lied and said his gun had been stolen. On July 26, 2022, Morales was walking home from a friend's apartment when she disappeared. Her remains were found nearly 20 miles away months later, in February of 2023, according to WSB-TV. Bryant lived in the apartment complex and worked as a courtesy officer where Morales' friend lived. Again, that's according to WSB-TV. The two had no prior relationship. According to police, Bryant falsely reported that his gun had been stolen from his unlocked personal vehicle on the same day Morales was reported missing. That's according to Fox News. Bryant's gun was later found in the same wooded area where Morales' naked body was discovered. So now what I'm going to do is bring to you the first day of the trial.
All right, we're going to switch gears now and bring you Court TV's newest case, the teen taken murder trial going on in Georgia. Former police officer Miles Bryant is accused of kidnapping and killing 16-year-old Susana Morales. She disappeared in July of 2022, and her remains were found nearly 20 miles away in a wooded area that following February. Well, today, opening statements got underway, and the defense is already indicating that the defendant will take the stand in his own defense and tell his story. But let's first take a listen to both sides in their opening statements.
There's a business here, King David Academy, and it captured the last images of Susana Morales' life as she walked home to her mom's house around 10 p.m. That is the last time anyone but the defendant saw her alive. The next thing that happened is she didn't come home. She never made it back to her mother's house. No one ever heard from her again. Not a single text message, not a phone call, nothing. She disappeared from life. You'll hear from an expert in cellular tower mapping, Investigator Wilbanks, who will tell you and show you his mapping. This is not his mapping. But he will show you that the defendant's personal phone was located in the woods right next to Susana's body within 2 hours of her disappearance. Not just that, the defendant's work phone was also located in the woods right after Susana's disappearance.
It is a tragedy what happened to Susana Morales. She's a beautiful young lady. I have spoken briefly with members of her family. They're very, very nice. As a mother, I cannot fathom the anguish that they went through. Makes me very upset at Mr. Bryant. But you don't have to like my client. And in fact, at the conclusion of this trial, you're going to think that he is the most callous, uncaring coward that you have ever seen. However, he is not guilty of the murder or felony murder in this particular case. What you have from the state is speculation. We found this, and we don't really know, but this is what we think happened. Particularly on the Life 360. They're not going to introduce to you any expert to explain the 360. You hear about it could have been a hard break, but no, they're speculating that it was thrown out of the car. Their whole case is based upon speculation. At the conclusion of the total trial, and you're going to hear from Miles Bryant, he's going to explain to you exactly what happened, and it is going to be supported by all of the evidence that the state is going to introduce to you.
Now, after opening statements, the first witness called to the stand was the victim's mother. She testified through an interpreter. She became emotional while telling the jury about the last time that she saw her daughter.
When Susana told you that she wanted to go to Esmeralda's house, did you let her do that?
Susana le dijo que quería ir a la casa de Esmeralda. ¿Usted se lo permitió? Sí. Yes.
And how did, approximately what time did Susana leave to go to Esmeralda's house?
Aproximadamente qué hora salió Susana para ir a la casa de Esmeralda? A las 6. At 6.
Was that moment as she walked away from your house, was that the last time that you ever saw your daughter?
Ese momento, a medida que ella salía de su casa caminando, ¿fue la última vez que usted vio a su hija? Sí. Yes.
Can you tell the jury what happened throughout the night
¿Le puedes recordar qué pasó durante la noche?
Después de que se fue Susana, como a los minutos después le llamé para ver si había llegado.
After Susana left, a few minutes later, I called her to see if she had arrived.
Al no contestó, le mandé un texto para preguntarle y me dijo que sí, que está.
Since she did not answer, I texted her and she replied yes, that she had arrived. Yes, around 9:40, I called her so I could pick her up.
Around 9:40 you called her, is that what you said?
Alrededor de las 9:40, ¿usted la llamó?
Sí.
Yes.
Did you talk to her?
¿Habló con ella?
No, ya no me contestó.
No, she did not answer.
And what did you do at that point?
¿Qué hizo usted en ese momento?
Le llamé varias veces.
I called and called several times.
Did you ever hear any phone calls or text messages back from Susana?
¿Alguna vez en algún momento escuchó una llamada o mensajes de texto de regreso de Susana?
Nunca más.
Never again. I called her friend Esmeralda.
No me contestó, entonces llamé a su mamá.
She didn't answer, so I called her mom.
You called Esmeralda's mom?
¿Mamá Esmeralda?
Sí.
Yes.
Okay. And did she answer?
¿Y ella le respondió?
Sí.
Yes.
And what happened?
¿Qué pasó?
Me dijo que nunca llegó Susana ahí.
She said Susana never arrived there.
All right, court has ended for the day there. Testimony resumes
Welcome back. Time to reveal something else you need to know tonight. Take a look at the big board. And who do we have? I don't know if you recognize her. It's been a few years. That's Amanda Knox. She was back in Italy, back in a criminal court, and got convicted again. This time for slander, for accusing the owner of the bar that she worked at for the murder that she was originally convicted of and then exonerated for. Slander in Italy is a crime. She apparently represented herself. So, as it usually goes, she did not win. But the good news for Amanda Knox, she's not going back to prison. She served 3 years for something she didn't do, so they gave her credit for that. So Amanda Knox will be able to, I guess, I don't know, go take a look at the Coliseum or something. Anyhow.
Regarding Amanda Knox, and I apologize. Let me go back to the case that was made mention of earlier. The dentist who accused of killing his wife and discussing with his mistress. Couple of pieces of couple of notices of evidence that the defense wants to take out if they don't totally drop the charges. Goes like this, starting with February 2nd, 2023. Quote, "Do you know anyone who can help me with my problem down here? I can pay handsomely. I want to be with you." February 3rd, 2023. "Hitting up a homeless person actually sounds like the only choice right now. I made $66,000 in January, and I want to desperately share that with you and help you. I feel so trapped." February 15th, 2023. "I'm looking forward to Thursday nights so much. Maybe we can come up with a solution. I love how resourceful you are. I want to bless your life." Again, prosecutors claim that the witness was interviewed. The witness that they want to exclude her testimony from. This witness was interviewed with investigators and voluntarily, and she asserts that the defendant is trying to exclude relevant, voluntary, reliable, and admissible evidence. They're requesting the judge deny the defense's motion without a hearing. They've already had his most recent court appearance on the 5th. His trial remains slated for August. All right. Now, I am going to hit the trigger warning first, because the next story that I'm going to bring to you is worthy of this trigger warning. All right. An Ohio woman is facing charges after police say she stabbed a toddler to death in the parking lot of a grocery store in a random attack. According to North Olmsted Police Detective Sergeant Matt Beck, the suspect, 32-year-old Bianca Ellis, was at the Volunteers of America store, a thrift shop adjacent to the grocery store, where she obtained some sort of kitchen knife. It's unclear if she paid for it or stole it. Police say Ellis then left the store, walked over to the Giant Eagle supermarket just after 3 p.m., and approached a 38-year-old mother who was pushing her 3-year-old son, identified as Julian Wood, in a grocery cart. Ellis allegedly stabbed the mother and child multiple times and walked off. The entire attack unfolded quickly, Beck said. The incident itself happened in less than 5 seconds, so the people that were near there did react and respond, but by the time the incident was already over and Ms. Ellis was already walking away. The young child suffered 2 stab wounds, one to the face and one to the back, and she, the mother, suffered one to her shoulder area. I am clicking on a link, and I'll get to that link in just a minute. Multiple officers responded to the parking lot after the department was inundated with 911 calls about the stabbing. Officers tracked Ellis down nearby and took her into custody without resistance. The suspected weapon was found next to Ellis when she was arrested. The mother and Julian were taken to a nearby hospital. Julian later died from his injuries. The mother's recovering from hers. Oh, I see what that was. That's for a GoFundMe. As a mother, I cannot even begin to fathom the sense of loss this family is going through, said North Olmsted Mayor Nicole Daly Jones. Police Chief Bob Wagner added, "Our condolences go out to the family. It's a very difficult time, I know, for them, but also for all the first responders." Officials say the motive behind the attack was unknown, and it appears this was a random act of violence. Ellis and the victims had no prior interactions, police said. Beck said Ellis was known to North Olmsted police because of a 2023 shoplifting incident at a Walmart in the city. More recently, she was arrested Thursday in the city on an outstanding warrant. Before the stabbing, Beck said Ellis had come to North Olmsted Police Department to inquire about property secured during the arrest. He said previous crimes never included a history of violence. There is no indication why she committed this. There's some mental health concerns that we have, but nothing concrete to this point, Beck said. Ellis has been charged with aggravated murder. Her bond is set at $1 million, and she's scheduled to appear on Monday, June 10. Scripps News Cleveland went to Ellis's last known address, an apartment building on Purita's Avenue. The maintenance director called the whole situation sad. He told Scripps News Cleveland that Ellis had been evicted 30 days ago. Court records showed she owed back rent. But in March, Ellis was in Kissimmee, Florida, where records show she was arrested on a trespassing charge. Court records there reveal Ellis to try to rent a room at a hotel, but didn't have any money and refused to leave when asked. She then told police she was on vacation from Ohio and that she wanted to go to jail. Well, Bianca, wish granted. But really, did you have to stab a 3-year-old to death in order to get there? Did you have to stab a mom in the shoulder in order to get there? I can't wait to hear what the update sounds like in that case. Next up. All right. This one I got to give you the same I got to give you all the same warning as I did with the Karen Reed case, okay? First of all, I have no skin in the game when it comes to Gypsy Rose. She did her time. I just say leave her alone. Let her handle her life the best way she can post prison. Now, she's filing a lawsuit against a content creator she previously worked with, accusing the blogger of fraud, breach of contract, and defamation. Gypsy Rose Blanchard, now legally Gypsy Rose Anderson, was previously released from prison in December 2023 after serving less than 10 years for the murder of her mother, Dee Dee Blanchard. Gypsy Rose pleaded guilty to the murder after the investigation into the case revealed that Gypsy Rose had been a victim of child abuse. Investigators determined that Gypsy Rose's mother had forced her to undergo medical procedures and surgeries that were unnecessary, as well as lied about Gypsy's health to get money. Dee Dee's murder garnered national attention, prompting Gypsy Rose to have contact with people during her prison term who were interested in publicizing her life story. Now Gypsy Rose and her family are suing one of the people she spoke to while in prison. In a lawsuit obtained by Court TV, Gypsy Rose and her family say they began talking to April Johns, also known as Francesca Fancy Maselli, in 2017. and that Johns presented herself as an up-and-coming producer, quote-unquote, with her own company, Mad Ginger Entertainment. Johns entered into a life rights option agreement with Gypsy Rose and her family. Under that agreement, the Blanchard family gave Johns interviews and access to elements of the case files, which included private medical records, family photos, and crime scene photos. The lawsuit claims the family terminated their agreement, but Johns did not secure any media rights or produce any marketable content. But despite ending their relationship across, the lawsuit accuses Johns of continuing to create and post content about the family against their wishes. Things escalated when Gypsy Rose's prison release date was announced. Quote, quote, I am so sick of Gypsy. Like, I honestly want to bury her so far down a rabbit hole, and I think if I dig deep enough, I can make her look so effing bad, read one statement, included in the lawsuit attributed to Johns. Another statement appears to question whether Gypsy Rose was the victim of abuse, saying, it ain't effing medical child abuse. We've been had. F it be, sue me. End quote. In the lawsuit, the Blanchard family alleges that Johns' content became more frequent, with her sometimes posting multiple times per day and often screaming and cursing. The family also alleges that Johns has continued to use the materials she accessed under the agreement in her posts. The Blanchard family has asked for a restraining order against Johns in addition to unspecified damages. The lawsuit alleges that Johns had been falsely accusing the family of stalking her on social media and has encouraged others to do the same. Now, again, no skin in the game, but we'll have to wait and see what becomes of this civil case. Next up, just as sure as the day is long and the weather's getting warmer, I knew this was going to happen. Chad Daybell's attorney files appeal following death sentence decision. As you know, a jury convicted Chad Daybell on all 8 counts, including first-degree murder for the deaths of Tylee Ryan, J.J. Vallow, and Tammy Daybell on May 30th, 2024. Daybell was given the death sentence just 2 days later. Now, defense attorney John Pryor has filed an appeal asking the Idaho Supreme Court to examine the verdict and the death sentence. In the notice of appeal filed Monday, June 3rd, Pryor asked the Idaho Supreme Court to consider the following questions. Did the court err in not granting Daybell's motion to dismiss the grand jury indictment in the case? Now, I'm gonna have a little fun with this. With each question, I'm gonna put myself in the position of the Idaho Supreme Court. Now keep in mind, these are just my opinions. These are just my opinions. They have no weight in this, okay? Let's go. Did the court err in not granting Daybell's motion to dismiss the grand jury indictment in the case? I'll say no, they didn't, because that grand jury indictment is what leads the case to go into court in the first place. Next, did the court err in ruling Dr. Davidson's report and testimony would be admissible in the case? Why would it be inadmissible? A doctor's testimony is as much credible as a police report, as a police officer's or high-ranking official in the police department as their testimony. Did the court err in allowing the prosecution to amend their indictment after they rested? I kind of doubt that, because if something in testimony led the prosecution to amend their indictment, then there you go. That's on them. Did the court err in denying the defense motion to dismiss the case? No. Look what he's charged with. you're trying to say that the prosecution's case didn't support any of the charges, you are sadly mistaken. Next, did the court err in providing the jury the most current jury instruction of reasonable doubt at the guilt stage? Absolutely. Absolutely not. When you that's what your closing arguments are for. If you're gonna give the jury the idea of reasonable doubt, you let them know that in your closing argument. That's the only way they're gonna be able to say the defendant is not guilty. Reasonable doubt. Last question: did the court err in providing the jury the most current instruction of reasonable doubt at the sentencing phase? Same thing. The answer: no. If you want the jury to apply reasonable doubt to making their sentence and rendering their verdict, you make mention of it during your closing arguments. You make mention of it during your opening statement. In other words, you're not doing what you're supposed to do. And whose fault is that? Anyway, Pryor also filed a separate motion requesting that a state defense attorney be appointed to represent Chad Daybell and assist in seeking appellate relief. Well, good luck to Chad Daybell trying to appeal his guilty verdict and death sentence, because he is definitely going to need both. Okay, we got the accused killer of Sade Robinson denied computer access in jail. We're gonna go to Judge Ashley Wilcott for a report.
We have a quick update out of Wisconsin. Maxwell Anderson, the man accused in the death and dismemberment of 19-year-old Sadie Robinson, was back in court today for a motions hearing. This morning, the judge addressed two different issues. One regarding the defense's request to give the defendant a computer while in jail in order to review materials in the case, and another where both parties sought to have the judge unseal a search warrant issued back in April. Let's listen together.
The defense filed a request relative to discovery so that Mr. Anderson can view all of the reports and videos and what I gather is voluminous material in connection with this case. There may be communications components of that computer, whether it's Wi-Fi or cellular connections that can create some complications. And even if you could turn those off, if they're physically present in the device, they could be reactivated. And it's, in some senses, like putting a cell phone in the middle of the jail. There's also issues surrounding how others may react to the defendant having a unique computer just for his use. Now, I appreciate that he's in protective custody, but other inmates certainly would learn about this, and that could create some downstream complications. So I think on balance, while it might be slightly more efficient, that the institutional concerns outweigh giving Mr. Anderson a computer. So I'm going to deny that request. The second issue I think is even less controversial. The parties had sought that I unseal a search warrant return and filed a proposed order.
With the proposed order identifies the search warrant as the one issued on April 5th for the residents on 39th Street, Your Honor.
Okay. I'll go ahead and, with the agreement of the parties, I'll go ahead and grant that request.
The judge has set a scheduling conference for July 12th, and of course, we'll continue to bring you more updates as that case develops.
And as things develop and I get those updates from Court TV, you guys will get it here at Bethea'S Byte Reloaded. Now, as promised, the update on Rex Heuermann. He has been charged in the deaths of 2 more women, and he has kept a document to blueprint the crimes. Let's take a look.
Major developments today in the Gilgo Beach murders case. Rex Heuermann has now been arraigned on 2 additional murder charges. He now faces charges for the murders of 6 women. New charges come just days after investigators finished new searches of his home. The district attorney for Suffolk County issued a statement today about the new charges and what was collected at Heuermann's home. Take a listen.
Now I want to discuss some of the newly discovered digital evidence in the case. Before I discuss that, I just want to clarify some of the things that we've been talking about in our earlier press conferences. You were asked I was asked specifically about smart devices and digital devices that were recovered from the home and business of the defendant in connection with this case. So I just want to catalog that for you so you get a sort of flavor of what it was. We recovered 15 different types of cameras. We've recovered 27 computers. We've recovered 58 internal hard drives. We recovered 22 external hard drives or solid drives. We recovered 46 cell phones. We recovered 9 Wi-Fi routers, 44 SD micro cards, which are like jump routers, 17 tablets, 42 USB devices, 8 laptops, 50 hotel cards, 4 GPS devices, 11 music devices, 36 SIM cards, 33 miscellaneous items, and 647 CD, floppy disks, or VSH or miscellaneous tapes. Again, in the months subsequent to the arrest, we've been endeavoring through our own office and with the help of the Secret Service to analyze that massive amount of data. And analysis of those devices has revealed, certainly, that Heuermann had a significant collection of violent, bondage, and torture pornography, which was dating back to 1994, and that material was very similar to the condition that the 2 latest victims were left in. In addition to that, it is alleged that the pornographic images that were accessed by Heuermann are consistent with the crime scenes of both Sandra Casilla and Jessica Taylor. Now, as part of our processing of the electronic devices, the task force discovered a Microsoft Word document entitled HK 2002 through 2004. That was discovered on a laptop in unallocated space, meaning there was an attempt to erase that document. But as most forensic experts know, that even when a document is erased on a device, it is the user could no longer access that document, but forensic experts using particular software can retrieve it, and this document was retrieved in this case. It was a locally created draft, which means the document itself was created on the laptop. It wasn't downloaded from the internet. The document was modified. It was originally created in 2000, and it was overwritten a number of times and modified between 2001 and 2002. Now, as alleged in the bail application, the task force believes that this is a planning document, and it was utilized by Heuermann to methodically blueprint and plan out his kills with excruciating detail. We allege that this document evinces the defendant's intent in committing the charged crimes, that his intent was specifically to locate these victims, to hunt them down, and to bring them under his control and to kill them. His motivations, meticulous planning, and clear intent is obvious. His intent was nothing short but to murder these victims. and we allege that the methodology, that the exact method by which these murders were committed, in excruciating detail in that document, is in some cases identical to the methodology to murder the 6 victims in this case. Now, I don't want to speak further on the document. I believe the document speaks for itself. So if anybody has any questions about the document, I'd be more than willing to answer them. But before turning it over for questioning, I want to reiterate, you know, right from the very beginning of this case, from the onset of the case, the first indictment, we said that the case was not over. We said we were going to continue to investigate the case of the Gilgo 4 and find more evidence. We've done that. We've said that we were going to expand the investigation both on Gilgo and off, and to investigate new cases. We've done that, and that's resulted in the 2 new charges that you see here today. So that's what we've done. That's what we've continued to do, and you know, my office, along with our partners, are not going to stop. This case continues.
Okay, a portion of a press conference held today after the hearing, the court appearance by Rex Heuermann, where he entered not guilty pleas for the latest 2 victims that he's now accused of killing 6 people. And boy, some of those things that they found, just the volume of it. Laura Uretzian is still with us. And Laura, what's your take when you hear that? It seems like we're talking a mountain of evidence, and as he said, some of it has excruciating detail. With excruciating, he used that word a couple times, and that it seems as though that's what these victims went through, a horrible experience. Obviously innocent until proven guilty, but your take on just the volume of things they found in this home?
Clearly the evidence against Mr. Heuermann is growing, and it's very obvious that the Suffolk DA's office and law enforcement are not going to stop with that. They're going to continue their investigation. It sounds like they believe that there may be more victims of this gentleman. So, and as far as the evidence is concerned, it's pretty damning. And again, it's a little too early and it could be circumstantial. I understand that. But when you add it to what they've got, or what they discovered early on when they initially filed the cases, you have my understanding is you have a number of pornographic videos, and some of the images and some of the things that you see on these videos are very similar, and in some ways identical to what has happened to these women. You have a man who had the home to himself. My understanding is they also found a book that has to do with the mind of a serial killer, profiling the mind of a serial killer. And we have a document that seems to be the blueprint of how to kill, how to organize this whole thing. And I'm sure they're not telling us everything. They have more, and they're not giving us the excruciating detail because it's still an ongoing investigation, and they're hoping to recover more. But again, I mean, this mountain of evidence and the amount of evidence, I mean, you heard the number of devices that they've gathered. They have to have Secret Service come in and help them out, because the idea for one law enforcement agency to go through this amount, this many digital devices is a lot, and we may have more to find out soon.
Yeah, imagine being the IT guy in that county. What? Celebrate 46 cell phones. Holy mackerel, that's a lot. And obviously they're continuing. Yeah, and continuing to pour over it. That document does sound horrifying because of the details. We'll get a break here, and we're going to hear more of this press conference. When we come back, we're going to concentrate more on the 2 newest victims that they've always been suspected to be the work of Heuermann, but today he had to stand and face charges against them. We'll talk about that when we return.
Now, guys, remember earlier when I said, when I made mention of in one of Julie Grant's opening statements that Rex Heuermann would be best off to think about taking a plea deal? Yeah, now would be a good time to even consider taking a plea deal. Here's why I'm saying that. I mean, he was originally charged with killing 4. Or he's ready to face charges of killing Jessica Taylor and Sandra Castilla. That was the 2 just latest victims that was discovered. And on top of it, he's got a document that that blueprints the crimes. Ladies and gentlemen, to say that Rex Heuermann is in hot water is a gross understatement. All right. We're going to go to a verdict watch right now. This is Tennessee versus David Swift. And David Swift was charged in the murder of his wife Karen. We are going to go directly to the verdict in this case.
Ready to go, ready for the jury? Yeah, we are. All right, I'll show you whenever you're ready, if they're ready. All rise. All right, let's have a seat. Good afternoon to you all. Madam Foreperson, has the jury reached a verdict in this case?
No, Your Honor.
Do you feel like that it is likely that the jury, on continued deliberations, will reach a verdict?
No, sir.
Let me ask you this. Has the jury considered the highest level of the offense?
Yes, sir.
Is there a disagreement as to the highest level of offense?
Yes.
That's where your disagreement falls?
No, I'm sorry. It is not. That is not the case for the highest offense.
Okay. Does the jury agree on the highest level of offense, that the defendant is either guilty or not guilty?
Yes.
What is the verdict in that?
Not guilty.
Okay. So the jury has found the defendant not guilty of first-degree murder?
Yes.
Okay. May I borrow the charge book for a minute so I can look at the verdict form? If you need it back to look at it, just tell me. Has the jury considered the second level of the offense attempted first-degree premeditated murder?
We did consider that.
Is there an agreement that the defendant is not guilty as to that offense?
Yes, sir, there is an agreement.
Has the jury considered the level of offense second-degree murder?
Yes, sir.
Is there an agreement that the defendant is not guilty as to second-degree murder?
Not guilty.
I have not asked you specifically, but are all of these agreements unanimous as to these levels of charges?
Yes, Your Honor.
Okay.
We have one shaking his head.
Beg your pardon?
We have one shaking his head.
I'm sorry. My question, and I'll come back in. My question was, is it unanimous that the defendant is not guilty of second-degree murder? And I'm going, since there was it's my question. Is there an agreement on that level of charge?
Agreement with who?
No.
I'd say not guilty on that.
Sir, ma'am. Not guilty as to second-degree murder. Is that correct?
Correct.
Okay. That cleared that up, General? Yes. Has the jury considered the next level of charge, attempted second-degree murder?
Yes, sir.
Do you all find the defendant not guilty of attempted second-degree murder?
Yes, sir.
Each of you? Ma'am? Okay, I'm looking at you because I want to see, and if you disagree, just let me know, okay? Now let's go back. We did not do this as a first-degree murder charge that I'm told you found him not guilty of. Is that correct? Okay, I see head nodding affirmatively, and attempted first-degree murder. Is that correct as well? Okay. Has the jury considered the charge of voluntary manslaughter?
Yes, sir.
Is there an agreement, or has the jury found the defendant not guilty of voluntary manslaughter?
There was no agreement.
No agreement? Is that the level of the offense at which there is disagreement?
Yes, sir.
Is that correct, ma'am? All right. Would the state like the jury polled as to the first four level of charges?
No, Your Honor.
Or as to the level on which there's a disagreement? I think since we don't have a verdict, there's no reason to poll the jury as to that level. You agree, Mr. Taylor?
I agree.
I'm going to ask each of you this question. You just tell me, would further deliberations be of any value?
No, sir.
No, sir.
Okay. Do you all believe that the jury is hopelessly deadlocked with respect to the charge of voluntary manslaughter? I see everybody nodding their head yes. The court will enter a verdict of not guilty as to the charge of first-degree murder. The court will enter the charge of not guilty as to attempted first-degree premeditated murder. The court will also enter a not guilty verdict with respect to second-degree murder. And the court will also enter a not guilty verdict with respect to attempted second-degree murder. The court believes that the jury is hopelessly deadlocked with respect to the next level of charge, that is voluntary manslaughter. Is there any reason that the court should not declare mistrial at this time, General?
No, Your Honor.
Mr. Taylor?
No, Your Honor.
Court will enter and declare mistrial with respect to the charge of voluntary manslaughter. I want to say something to you. The jury, having completed the work as required by law and by this court is discharged and excused with the sincere gratitude of the court. Judge Parham and Mrs. McMahon have asked me to tell you that you are excused from further service in this term. You do not have to report in August. You've done more than a share. I understand the personal sacrifices that each of you have made to be here every day on time, and specifically the sacrifices over the 11 hours plus in 2 days that you have spent attempting to reach a decision in this case. I thank you for your work, for your time, for your dedication to this case, because that is dedication to our system. That's dedication to our jury system and our effort to provide a fair trial for anyone who's accused of a criminal offense. Don't be frustrated or discouraged because you weren't able to resolve the case fully. It happens. You did exactly what the court and the attorneys ask you to do and what the law requires you to do, and that is to consider a matter on which reasonable minds can obviously have differing opinions. Okay, you did exactly what we asked you to do. You're released from the previous restrictions of discussing the case or from viewing social media posts or the video of the trial. And I bet every one of you want to go home and rewatch that right now. You can talk with anyone that you please, but you're under no obligation to talk to anyone whatsoever. I think some of the media have provided you with their contact information rather than besieging you once you leave the courthouse. That is not to say that you may not be met with questions and cameras. It is your decision whether you want to talk to anybody about any aspect of this thing. If you watch any portions of the trial later on or start reading social media posts, you're going to find out that there was some information that the court, and when I say the court, I mean me, that I excluded from the trial of this case because I did not think that it passed the requirements of the rules of evidence. It was my call. I stand behind my decision on that because I thought that's what the law required me to do. But you'll be surprised when you do see that. It has been a distinct honor and a privilege to serve with you, each and every one of you in this case. I'm proud of you, and I wish you the best. You're released. Officer Elam will help you get your electronics and any personal things you have there, and once you get those, you are free to leave. I think, have you already handed out excuses, or you have those? We got those to give you. Maybe.
She's going to give each of
Yeah,
you
Emily
a
can.
badge.
Yeah, okay. Can follow them in and hand out those. Thank you very much for your service. Once again, let's rise for the jury. All rise.
Okay, to recap, a jury found David Swift not guilty of first-degree premeditated murder, not guilty of attempted first-degree premeditated murder, not guilty of second-degree murder, not guilty of attempted second-degree murder, but they were unable to reach a unanimous verdict on the charge of involuntary manslaughter. Therefore, the judges declared on that charge alone a mistrial. We'll see what happens in that, but he also has separate charges in Alabama where he is accused of stalking his second wife from whom he is divorced. We will see what happens when that case comes to trial. Next up, a woman is accused of killing her 3 roommates. She was captured in New York. A Virginia woman accused of killing 3 people captured in New York State on Thursday. Alyssa Jane Venable, age 23, was wanted in the deaths of her 3 roommates, whose bodies were found Tuesday night during a welfare check. The Spotsylvania Sheriff's Office identified the victims as 77-year-old Robert John McGuire, 60-year-old Gregory Scott Powell, and 65-year-old Carol Ann Reese. Authorities say they died from upper body trauma. Venable was captured Thursday after police spotted a vehicle that matched the description of her car driving on Interstate 86 in Steuben County, New York. Authorities said Venable refused to pull over when a traffic stop was initiated, prompting police pursuit. Police used tire deflation device to stop Venable's car. Authorities in Virginia said New York State Police will be obtaining a fugitive warrant for Venable as well as arrangements for her extradition. Court records will show Venable was previously arrested on May 16th on simple assault charges at a McDonald's parking lot. That's according to Scripps News Richmond. And I will, when I get more updates on this particular case, I'll be sure to bring them to you as well. We have another guilty plea now coming out of Ohio. All right. We're going to go to the courtroom right now, where an Ohio man is going to plead guilty to his to a cold case. His fiancée.
Amended involuntary manslaughter, which is a felony of the 3rd degree. You understand that a felony of the 3rd degree carries a maximum stated prison term of 36 months and a maximum fine of $10,000.
Yes, Your Honor.
This document on the 2nd page appears to have your signature above the signature of defendant. Is that in fact your signature?
Yes, sir. Yes, Your Honor.
Prior to signing that document, did you have the opportunity to read it and go through it with your attorneys?
Yes, sir.
If you had any questions about anything on that document, were you given an opportunity to ask those questions?
Yes, sir.
And were you supplied with any answers that you may have needed in response to those questions?
Yes, sir.
Are you satisfied with the legal representation and advice that you have received from your attorneys in this case?
Yes, sir.
Is there anything that you claim that your attorneys should have done for you or could have done for you that they have failed to do on your behalf?
No, Your Honor.
The prosecuting attorney is going to read into the record the statement of facts that make up this charge. I want you to listen carefully to those facts, and when they're finished, I'll ask if you agree and understand that those facts are true.
Thank you, Your Honor. As to count 1 involuntary manslaughter, on or about August 13, 2011, in the late evening hours to the early morning hours of August 14, 2011, in the area of 5214 Dorshire Drive, which is in the city of Fairfield, Butler County, Ohio, John Carter did cause the death of KAITLYN Markham as a proximate result of the offender committing a misdemeanor of any degree, in this case being assault. This constitutes the offense of involuntary manslaughter, a felony of the 3rd degree in violation of Ohio Revised Code section 2903.04b.
Mr. Carter, did you hear that statement of facts?
Your Honor, he did, and Mr. Carter, if we may on his behalf, John Carter stipulates that he committed the offense of involuntary manslaughter consistent with Ohio Revised Code 2903.04b. That is a felony of the 3rd degree, specifically that on the date specified in the indictment, he did cause the death of KAITLYN Markham by the commission of a misdemeanor in the city of Fairfield, Butler County, Ohio. He's in a guilty plea with regard to that.
Mr. Carter, when we come back for sentencing based upon this being a felony of the 3rd degree, the court will have 2 options. I can sentence you to a term of incarceration, ODRC, of up to 36 months, or I could place you on community control. If I sentence you to prison, once you're released from prison, you then will be placed on a period of post-release control. It's a mandatory period of time based upon the nature of this offense. It is not more than 3 years, but no less than 1 year. So from a 1 to 3 year period, you will be on post-release control. During that time, you'll be supervised by the adult parole authority. And if you violate their rules, they can send you back to prison for up to 1/2 of any sentence that I impose for increments of 9 months at a time. Do you understand that?
Yes, Your Honor.
With regard to this case, there is no presumption of prison time. There will be a sentencing hearing. You'll be afforded an opportunity to have a pre-sentence investigation, which you'll participate in that interview following today's court proceedings. And ultimately, this court will weigh the various factors that the law requires in determining what the appropriate sentence will be in this case. Do you understand that?
Yes, Your Honor.
If I do not sentence you to prison and instead place you on community control, it will be for a period of up to 5 years, during which time you will be supervised by the Butler County Adult Probation Department. That could include local jail time. It could include time in what we call a community-based correctional facility, or it could include other sanctions that this court may order. If during the period of 5 years that you would be on community control and you violate the terms of community control, you would still face going to prison for the original possible maximum sentence. Do you understand?
Yes, Your Honor.
We now need to go through your trial rights, because if you enter a guilty plea, you are waiving your constitutional rights, the first of which is a right to a trial by jury. You know that this matter is already set for a jury trial, 5 weeks of a jury trial. And you understand that you have the right to have 12 jurors sit over here in this jury box and listen to all the evidence that will be presented from that witness stand over the course of those weeks. The state would have to prove beyond a reasonable doubt each and every element of the offense before that jury can come back from their deliberations and ultimately find you guilty. And you're waiving that right to a jury trial. Do you understand that?
Yes, Your Honor.
You also have a right, should you choose to do so, to have a trial to the court, a bench trial, rather than a jury trial, where I would be the one that would listen to all the evidence that would come out during the course of the trial, and I would be the one to have to find that the state has proven this case against you beyond a reasonable doubt before I could find you guilty. And you are waiving that right. Do you understand that?
Yes, Your Honor.
You're giving up your right to confront the witnesses against you, meaning the state must physically produce its witnesses here in this witness stand and have them testify under oath to each and every piece of evidence that they are putting forth. Your attorneys then have the opportunity to cross-examine each and every one of those witnesses while those witnesses remain under oath, and you're waiving that right. Do you understand that?
Yes, Your Honor.
You also have a right to present your own defense. And if you have a witness that you thought was essential to that defense, even if it's someone that said, I don't want to get involved, I can't be bothered with this, it wouldn't matter. Because if you thought that they were necessary and your attorneys issued a precipice, the court would then issue a subpoena, which is a court order, compelling those witnesses to show up and offer their testimony during the course of that trial. And you're waiving that right. Do you understand that?
Yes, Your Honor.
Lastly, perhaps most importantly, you have a right against self-incrimination. You have no obligation to say anything about the facts of this case. If you took your case to trial, and if you chose to exercise your right to remain silent and sat at counsel table with your attorneys doing everything that they would do during the course of the trial, selecting the jury, making their arguments, questioning the witnesses, at the conclusion of that trial, should you decide that you did not wish to testify, I would instruct the jury. They are not allowed to consider your silence for any purpose whatsoever when they go back and deliberate, because you, like anyone else accused of a criminal offense, have a right to remain silent. But if you enter a guilty plea here today, you're clearly waiving that right. You are offering that guilty plea, which would function as a complete admission of this amended charge. Do you understand that?
Yes, Your Honor.
Do you have any questions about anything that I have covered with you here today?
No, Your Honor.
Do you have any questions about anything on the 2-page guilty plea and jury waiver form that you signed?
No, Your Honor.
Are you giving up the rights that I've explained to you here today freely and voluntarily?
Yes, Your Honor.
What is your plea to count 1, involuntary manslaughter, a felony of the 3rd degree?
Guilty.
The court finds that the defendant understood the waivers of constitutional rights and what those rights are, the effect of his plea, the nature of the charge, the maximum penalty involved, and, if applicable, his eligibility for probation or community control sanctions. The court may proceed with judgment and sentence. The court further finds the defendant understood the plea negotiations concluded between the defendant's attorneys and the assistant prosecuting attorney and the prosecuting attorney, and that the underlying agreement upon which this plea is based was stated on record in open court. The defendant entered his plea of guilty both orally and in writing in open court to the offense set forth in the written plea. The court further finds the defendant is making this plea voluntarily upon evidence presented and representations made and accepted. The court finds there is a factual basis to support the charge and the plea. The court finds that this day the defendant, in open court, was advised of all applicable constitutional rights and made a knowing, intelligent, and voluntary waiver of those rights pursuant to Criminal Rule 11. The plea is accepted and ordered filed. The court finds the defendant guilty of the offense to which he has entered his plea. Based upon our discussions at our pretrial conference, the sentencing hearing in this matter will be set for July 18th at 2:30 in the afternoon. That having been said, I always afford counsel the opportunity to place anything else they wish to place on record today for the purpose of today's hearing. Mr. Moser?
Yes, Your Honor, I do. I'd like to read the following into the record, Your Honor. The guilty plea by the defendant, John Carter, concludes the investigative work of a number of law enforcement agencies, my office, and other investigative professionals, and brings absolute, undeniable finality to the question of who is responsible and accountable for the disappearance and death of KAITLYN Markham. The investigation of KAITLYN Markham was frozen in time until my cold case investigator, Paul Newton, asked me if he could look into the case for one final review because the crimes of desecration of a body and tampering with evidence had already expired based upon the statute of limitations. All that remained was homicide. It needs to be said that a key component of that review was jointly uncovered by my Chief Assistant Prosecutor, Brad Burris, and the investigator, Paul Newton, that led to the subpoenaing of 87 witnesses for a trial of this case. If this plea, as offered by the defense, had not been made and accepted by me. In these TV times, where there is a popularized trial expectation of a confession, photos of a crime in progress, DNA, and fingerprints leading to a fast resolution, there was none of that. As such, in this case presented the most extensive and challenging collection of circumstantial evidence never before seen in this office to reach the guilty plea today and end the dissembling of the defendant and his alibi that have gone on for way too long. My trial team involved the near daily dedication of Assistant Prosecutor Brad Burris, Assistant Prosecutor Katie Pridemore, investigators Paul Newton, Mike Regal, Pete Langeman, John Horn, as well as criminalist Ali Wiseman, and City of Fairfield Detective Larry Green, and myself. As seen in many plea negotiations, there will be those in the public that agree, disagree, or have no opinion. But it is necessary to say that justice for KAITLYN has been done with the absolute finality in all respects, with the answer given today by his plea of guilty for responsibility for the death of KAITLYN Markham, regardless of the name given to it in these proceedings. Thank you, Your Honor.
Thank you, Mr. Moser. Anything on behalf of Mr. Carter?
Your Honor, we're asking if the bond be continued. This matter has gone on for approximately 14 months. Our client posted a $1 million bond. He's been on electronic monitoring. There have been no issues during the time that this case has been pending. Has strong ties to the community, grew up here, his family is all here, and there's been no evidence of any kind of issue with regard to flight. So we're just asking the bond be continued for disposition.
We'll defer the court. Thank you.
The court notes that Mr. Carter has complied with all issues of the bond order previously. The court notes that he is present here today. Mr. Carter, obviously, you are ordered to continue to make those same appointments with the pretrial release officer that you have been assigned to. You are also ordered to immediately report to the probation department for the purpose of the pre-sentence investigation immediately upon leaving here today. Any failure to abide by those conditions will result in immediate revocation of the bond. Understood?
Understood.
We will allow the bond to remain in place until our sentencing date, July 18th at 2:30.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, Judge. Thank you, Counsel. Mr. Burris. Thank you, Your Honor.
So John Carter pleads guilty to the murder of KAITLYN Markham, whose case was one of the biggest cold cases in the tri-state area. Carter had been free on bond since his April 2023 arraignment. He'll be sentenced on he was scheduled to go to trial on June 24, but after pleading guilty, the judge has set his sentencing date for July 18th. Carter is facing up to 36 months in prison. Next, I chuckle at this is because I never thought I would have to call out a legal Karen, a true crime Karen, but ladies and gentlemen, here's our true crime Karen, Susan Boone. And to nobody's surprise, she is complaining about her eighth attorney. Let's go to Julie Grant as she gives us this report and find out exactly what Susan Boone is complaining about.
The defendant in the suitcase murder trial is due in court this morning for a status hearing. That's right. Defendant Sarah Boone is in court. This woman is accused of getting her boyfriend to crawl inside of that suitcase, zipping it up, and then leaving him there to die. She was arrested in 2020. Her case has experienced numerous delays, most of them caused by her, because she either fired her attorneys or they quit, perhaps because she was intolerable. Let's go into the courtroom together now. Her latest attorney is addressing the court. Let's watch together.
Judge, I've obviously not seen the letter. Ms. Boone is correct. She has walked out of the last two visits when I've tried to review things with her. Just so the court knows, I've spent probably 20 hours, a little bit more, a little bit less, with Ms. Boone. She has lots of lists, lots of questions. In reviewing the court file, she was distressed previously about having access to her lawyers. I have taken collect phone calls from her that are at my expense. JAC doesn't reimburse you because I think it's important for clients to have access. I have spent...
Hang on, please. No one's interrupted you this morning, Ms. Boone.
As I said, I've spent over 20 hours going through her questions, going through her lists. When I tried to update her with regard to the depositions that I took recently, she opted to exit the jail conference. When I tried to review some things with regard to discovery as to things I wanted to make sure she was aware of, she walked out. She has asked me repeatedly for a copy of some medical records. Based on the discovery I got from the previous attorneys, one of the copies of those medical records had her handwritten notes. So she had a copy given to her previously. She'd reviewed them with previous attorneys. I sent her a new copy. Some of the things that she thinks are important from a lawyer perspective, perhaps I don't attach the same importance to, and you try to explain that to a client. you know, I know the court's in a difficult position, but at this point, we're at that impasse of, if she walks out of every conference that I have with her, I'm not sure what that says about the attorney-client relationship.
Ma'am, you said there was something else that you had other than a 58-page submittal or letter. What other information is it that you're seeking to have me take a look at?
It's things that I've been working on in the meantime. It's things that she likes to tell me is not necessary, but I know for a fact it is necessary. She likes to, in quotes, put things to rest all the time and constantly tells me I'm not having this conversation with you. So I'm not going to waste my time, and I, being in jail, have supposedly abundant amounts of. She's not going to waste my time because she's not going to explain something to me. And I have taken it upon myself to explain it to myself because she refuses to do so. I don't understand what it is that she has against me. I have told her from day one that her snotty attitude was inappropriate, and I try very hard to bear with her and her attitude. I don't know what it is that I'm doing wrong to her, but I feel that her attitude has equaled prejudice, which is not in my favor, especially considering she supposedly represented my life.
Okay. Give me an example of, if you could, of items that you believe are important Ms. Cashman is not giving attention to or dismissing as you may have framed it.
Yes, Your Honor. She likes to tell me that I don't like her answers. She's not giving me any answers to this. I've written 3 pages worth of questions, but I'm still waiting for her and any other attorney to actually answer for me, such as, why can't I have a bond? Why can't I have a download of my phone? Why can't I speak to my investigator? Why can't I have my medical records? Why can't I fully utilize my constitutional rights? There's 3 pages worth of questions that I have.
What constitutional rights specifically?
I'm very leery about having a fair trial at this point. There are a handful of other amendments that I have been researching and working on and trying to incorporate. To me, what I have written to you is obvious, and apparently from the correspondence that I get from the world, South Korea was the last place that I received correspondence. They obviously see the same thing. So I don't know what I'm doing wrong other than wanting to have a very successful outcome. It's just been long and drawn out, and I believe that God obviously believes in me as much as I do him in order for him to give me this very unique adventure that I am on, and I'm doing my best to let everyone know who I really am as opposed to the malicious murderer that everyone thinks that I am. I don't feel that she can do that properly. I still always, the reason why I'm here is hope that she will come in with a gentle, softer side and actually listen to what it is that I'm saying and see the bigger picture other than what's the one avenue that she keeps going down. There's other ways to win in more than one way. I'm not sure what I'm supposed to do, but I'm not saying that I'm trying to remove her. I'm just trying to ask you, please, forgive me for having to ask you for this. If you could please let her know, please, to just be nice to me and have a welcoming attitude, and things will probably change, and I will not get up and I walk out. Please don't lie to me. Please don't give me half-truths. And
What instances where there's been falsities or lies that have been told to you by Ms. Cashman? Can you give me an example?
my biggest one, Your Honor, is for me being here ongoing 5 years, no one has ever bothered to try to get me a bond.
What's the lie? You said that she has lied to you. What is the lie?
The process of getting a bond. She lied to my brother in regards to telling him that he would need to come down to the courthouse to have multiple photographs taken for documentation. He would have to bring the security information, deeds to his house.
Oh my, there's so much to say here. Where do we begin? Let me bring back in my friends, Tommy Pope and Michael J. Brown. Okay, so we're on lawyer number 8. God bless this woman, Patricia Cashman, the attorney. We just saw the back of her head, the blonde curly hair, addressing the judge. saying she spent 20 hours with Sarah Boone. She's even taken collect calls at her own expense. She serves with the Office of the Public Defender there and has taken calls that she's had to pay for out of her own pocket when she's not making a lot of money, you know, because she wants to be devoted to her client, and her client is walking out of discussions with her, and they have reached this impasse. Tommy, Sarah Boone has had a problem with every single attorney. Do you think the problem is Sarah Boone?
You know, at some time, you know, you've been through 8 or 9 relationships, and it's always them. Maybe it's not. You know, I was thinking as she was talking, inside Ms. Cashman's head is, "Oh, Judge, please relieve me. Oh, Judge, please relieve." Because, you know, the defendant was saying, "Oh, I don't want her to leave. I just want her to be nicer to me." Michael could probably shed some light on this. I would be terrified to be held hostage, you know, by this defendant, because I think what she's really doing, she is effectively denying herself of counsel. You know, you've got a right to be present in the courtroom, but if you have misconduct, you can be removed. We've seen that in other cases. I think that's in essence what she's doing here. I don't know what state, you know, and what their rules are, but it seems to me a matter of time you're going to have this, because she thinks she's smarter than all of her attorneys anyway. Just go ahead. It'll be misery, but let her represent herself. I think the worst scenario, and again, Michael could shed some light, I'd hate to be a defense attorney tied to this client. Oh, yeah. I mean, I guess basically you'd sit there in the courtroom, let her run her mouth while you checked your messages. And worried about your bar license.
Right. You know who I'm thinking of? Our friend Kirk Nurmi with Jodi Arias. You know, I mean, poor Kirk, you know, wrote a book about it. His life with Ms. Arias. He's never been the same since. God bless him. Great guy. It saved her life, by the way. So yeah, Sarah Boone. Okay, obviously, she is the common thread with all these problems, or all these 8 lawyers bad. No, they're not. We've seen them in court. They are excellent attorneys. She's fortunate to have them. Michael, I want to know what you thought when we heard Sarah Boone speak after she tried to interrupt her lawyer and the judge quieted her down. And she goes, "I just want her to be nice to me. I want her to be more loving." She's not a therapy dog. She's her lawyer. Michael, what do you think?
You know, Julie, Tom and I are laughing, and we can laugh because we're not the attorneys in that courtroom.
Thank goodness.
So I'm watching it, and anybody who's done this, we've all been in that situation, and it's not a pleasant one, because you want to do your job and they won't let you do your job. I think it's clear that what ultimately is going to happen here is she's going to be representing herself, and nobody wants that. The judge doesn't want that. The prosecutor doesn't want that. The jury doesn't want that. But she effectively is going to cut ties with any attorney, and ultimately she's going to have to stand up there and represent herself, and that's the worst possible thing that could happen to any defendant.
You both are so smart. I think that is the biggest takeaway. You both are right that, as you said, Tommy, she's effectively in her behavior denying herself counsel. And as you said, Michael, unfortunately, this is how this is going to go. And the judge at some point is going to say, okay, TikTok, you know, this has been going on for years. We're going to stop it at some point, and then we're going to see her pro se, which let's just get on with it, right? Since she's, like you said, Tommy, she thinks she's smarter than everybody. Perhaps she should just represent herself and get what she called, she said she wants a very successful outcome. Her boyfriend died, and she filmed it and taunted him. So there is that. Tommy and Michael, stand by, please. We're going to hit a break. There's more from the hearing. It's not over, my friends. It's still going. We just have to hit our first break of the hour. This is Court TV Live, and as we head to the break, let's remember the victim on the right side of the screen, Mr. George Torres, who lost his life in that incident with Sarah Boone.
I'm stopping this right here for the moment, simply because I'm laughing because she wants her attorney to be nicer to her. Karen, I mean Sarah. Let me say this for record. Let me say this for prosperity here. Your attorney is under no obligation to be nice to you, to baby you, to coddle you. They have but one job. Put on a vigorous defense for you and let justice be served. End of discussion. Now, you went through 7 attorneys before her. If you can't handle this one, like Julie Grant and her guests have been saying all this time, your best bet is to represent yourself. But here's a fair warning. A fair warning. She who represents herself in court has a fool for a client. And defendants have been pretty much and forever in criminal cases. Just saying. Quick update in the Alec Baldwin Rush shooting case. Now, earlier I mentioned that the prosecutors want to try to get Hannah Gutierrez to testify against Alec Baldwin. Now, there's a quick breaking news update that he's facing a new lawsuit from the victim's family. Let's go back to my good friends at Court TV.
We have some breaking news now we want to share with you. This morning, actor Alec Baldwin is named in a brand new lawsuit for his alleged role in the fatal shooting on the set of the movie Rust. Now, this comes just weeks before Baldwin's manslaughter trial is set to begin for the shooting death of cinematographer Halyna Hutchins. This lawsuit was filed by Hutchins' family. It names 25 people and companies as defendants, including armorer Hannah Gutierrez and former assistant director David Halls. Now, attorneys are seeking compensation for Hutchins' family, but the amount is not specified in the suit. Court TV is following this developing story, and we will bring you more updates throughout the day.
And I am definitely keeping an eye on this case in both the civil and criminal cases. And when I get the updates, you will get it here at Bethea'S Byte Reloaded. Now, I had scheduled statements from Julie Grant for this week, but I don't think I'm gonna have time to get through them all tonight, because I have one. No, actually, I have time. I have time for at least one, and that has to do with one case that I mentioned earlier. That has to do with Chad Daybell. The so-called doomsday prophet should have foreseen this coming. Not just the guilty verdict, but the death sentence that goes along with it. So, 149. All right. So, guys, I'm gonna go ahead and let you hear what Julie has to say in this
statement. Goodbye, Chad Daybell. You prophesized that our world was coming to an end, and now the law prophesized that you are coming to an end. Idaho law says that when you commit such heinous crimes, the murder of your first wife and the murders of your second wife's 2 children, all to inflate your bank account and your ego, you deserve the worst punishment that the law allows. The jury followed the law, and their verdict makes sense. What doesn't make sense is that Chad Daybell didn't put on one shred of mitigating evidence to save his life in the penalty phase. Not one witness was called. And that very foolish decision makes me wonder if he wanted the death penalty. I mean, think about it, my friends. Maybe the prophet thinks he's smarter than all of us. Maybe he thinks that he's going to reign supreme in the afterlife. I think he's a depraved, despicable, delusional, sorry excuse for a father and a husband. I think he better use his portal to go ask God for mercy on his filthy soul. He used religion to murder 3 innocent people that he was supposed to love. It doesn't get any sicker or more sinister than that. But the former grave digger figuratively dug his own grave in life, as he is now a convicted killer and sentenced to death. And Tammy, Tylee, and JJ got justice. They haven't died in vain. They were loved, and they will be remembered, while he will be forgotten.
I can't tell you how much I agree with Julie on that statement. Chad Daybell literally dug his own grave, and now he's going to be buried in it. While his other half, I can't call her better half because she's as bad as he is. She's spending 3 life sentences behind bars for Tammy, JJ, and Tylee. Now, she's pretty much gonna have to go another life sentence because her husband is headed to death row. For some, justice is sweet. For others, not so much. Bottom line, justice was served. Appeal? Good luck with that, Chad. I got a feeling that this one's gonna fall. This appeal process is gonna fall so hard. It's gonna lead you straight to lethal injection, perhaps. And then we all know for sure that justice is served. That's all I got for Bethea'S Byte Reloaded this week. Only on a sizzling Saturday night. Thank you guys for joining me. If you like what you saw, you can there are a few ways you can help out with your support. You can go the free route, but just by liking, sharing, dropping me a comment, and subscribing. You can tip me PayPal/EKB316, Cash App $EKB316, or Venmo EB the Last Outlaw. Nothing's obligated, but it's always appreciated. You can hit me up on social media. Hit me up on Facebook at Bethea'S Byte Reloaded. On X, formerly known as Twitter, at EKB316, these in all caps. Here on YouTube, at Bethea'S Byte Reloaded. Instagram, at EKB316, all lowercase. I will link this video in my bio on TikTok. That's at King of Hearts 316 2021. Or you can email me at kingofhearts316_09 at outlook.com. All right. So let me go ahead and put a nice bow on this. This is your home. This is true crime news without the drama, where your opinions matter. Lively debates are encouraged. Your voice is heard, and above all else, justice is served here. This is Bethea'S Byte, and it's reloaded. even on a sizzling Saturday night like this. If you had a good time, please let your friends know. And I will be back again in this week. Thank you so much for joining me. And until we do this again, you all know what to do. Bite this. Thanks for watching and joining me here at the drama-free true crime destination. Be sure to like, share, subscribe, and drop me a comment on this video. And be sure to follow Bethea'S Byte Reloaded all over social media. This is Bethea'S Byte, and it's reloaded.